All right. So I want to go ahead and call back up the Meister versus McDaniel matter.
What was your name?
Ma'am, if you just give me just 1 moment.
Okay.
Yes, ma'am. Thank you.
Oh, yes.
All right. I'm Judge Marty McGee, and I am calling the matter of Meister versus McDaniel. I understand there's a number of motions on, but particularly there is a motion to quash a subpoena. I want to address that first. Then I've got some other matters that I think will be shorter in duration. I want to come back to those. So with regard to the motion to quash, let me first say, if you all please state your name for the record, who's present.
Good morning, Your Honor. I'm Elizabeth O'Brien from the North Carolina Department of Justice, and I'm here appearing on behalf of Judge Hennett.
All right. Yes,
Your Honor, Keith Black on behalf of the plaintiff, Emily Meister.
Yes, ma'am.
Dr. Tigress, McDaniel, J.D. And before you hear it, Your Honor, I have a motion to recusal as to yours, and you're aware of that, fully aware. I thought I recognized you from Guilford County, correct?
Let me just say, with regard to whether I'm fully aware of that, ma'am, I don't know that I am. I don't know that I've received a motion for recusal, but
you have in Guilford County. You're well aware because you responded to it by email. In fact, through the feed as it relates to my complaint against Goodwill and City of Concord and Concord Police Department. You're very well aware. You actually communicated with us first. You initiated the correspondence, and I have provided extensive documentation as the court has obfuscated otherwise, but is always well aware of that I'm very thorough in my filings. So
let me say, a lot of cases come before me with regard to my communication with you through a case. I don't simply recall that. What would be the basis of a recusal?
It would be for due process violations. I can pull up the emails, especially since I have my laptop.
Ma'am, if you'll just explain to me the basis for a recusal.
Yes. Again, due process violations, that's sufficient. Under the North Carolina Supreme Court and General Assembly as it relates to, and the constitutional law as it relates to substantive and procedural due process, when there is a due process violation, that judge is definitely subject to recusal. Now that recusal then, when moved upon by the aggrieved party, then must be deferred to another judge to hear it, because you're well aware you're not a new judge, quote unquote, so you're familiar with the Latin maxim that you can't be a judge in your own cause, and the North Carolina Supreme Court judges bench book directs any judge that is subject to recusal, and where there is even the appearance of partiality, then they are to defer that matter to another judge until there is a decisioning, then that judge who is subject to the recusal cannot hear any motions. And this, again, is something that I brought up prior to even coming to court. So this is on the court's liability, not mine, because my concern was that I would be subjected once again to abuse of my time, abuse of my constitutionally inviolate rights to due process, and a fair hearing.
If I could interrupt you just one moment.
Yeah.
So what would be the factual basis for a recusal?
I've already told you the factual basis for the recusal. The legal reason supersedes, number one, the factual, but the factual encompasses the legal reasoning, and there's no way to take the facts away from the legal reasoning that supports it. I can pull up the emails very easily and show you as to you being subject to recusal and validly subject to recusal.
Okay, ma'am, when I say the factual basis, like a factual basis for a judge being recused would be when you say a judge can't be the judge in their own case. If the judge has a factual or a financial outcome in the case would be a situation where a judge would need to recuse. That's a factual basis that the judge has some sort of financial interest. This is a dispute over some farmland and the judge owns part of that farmland would be an example. So I don't understand when I ask you what would be the factual basis for my recusal, what would be the underlying facts that would require that?
So as both a doctor and a Juris Doctorate in applied sciences, more specifically, my cognitive skills are generally unrivaled. I understood your statement and I responded by answering with due process violations. You, in that particular case in Cabarrus County, have committed countless due process violations against me during the course of my litigation. I can list them off if you would like. Is that what you would like for me to do?
Yes.
Sure. So the number one due process violation is that you proceeded with a hearing ex parte when there was a service issue. And that service issue, then you proceeded upon not acknowledging the fact that I had moved for a continuance when I learned about the service issue. In that I was not able to appear, that it was, and my inability to appear was based on the fact that I was unavailable and validly unavailable. And the opposing counsel had actually scheduled that motion and that hearing, or hearing thereupon, without regard for my availability, which both of you and I know that's a Rule 6 violation of the rules of general practice for North Carolina Superior and District Courts. And it states that there shall be a continuance when an opposing counsel or moving counsel, scheduling counsel, has scheduled a hearing without regard for the other side's availability. That's straightforward. Shall is a directive, it's a mandate. So that was one. There are several.
If I start talking, if you please stop, because I need to ask you some questions. So, what case was that? Again,
that was McDaniel versus Goodwill, City of Concord, and Concord Police Department.
And what is the status of that case?
Oh, it's still pending. But you're no longer
still pending where?
Again, in Cabarrus County.
All right.
Would you like the case number?
No. Okay. Anything else?
Is this helping you to recall? Because there's more, because you asked me for more.
I'm happy to hear whatever you contend on the factual basis.
If you'll give me 1 second, I'll go and I'll actually pull it up. But you cannot validly nor lawfully hear this matter. And of course, when I say that, and unfortunately having been victim to large-scale fraud by the North Carolina judiciary, even where the appellate court has been found in my favor and overturned certain judgments, judges still, unfortunately, misbehave and do not follow the law. So when I say that you cannot, the law is going to.
Ma'am, if you'll just answer my question, I'll give you an opportunity to tell me what facts require recusal. I'm happy to hear from you on that.
Your Honor, these are those facts. This is part of those facts. Give me 1 second.
Thank you.
Would you like for me to pass this up with the bailiff?
Ma'am, if you just read what you tell me the information that's on the record.
As far as your motion for recusal, it's indexed between 16 and 20 in 24 CBS 000821-120, Cabarrus Superior Court. Actually, you and Wood, because Wood, ironically enough, made an appearance in that case, which was especially disturbing. But
ma'am, if you could help me without editorializing, if you'll tell me what you said the order says or what the email says.
I'm not editorializing when it's facts.
Ma'am,
so
if you would not argue with me, you should accept the ruling decisions of the court gracefully. If you'll just tell me the information I requested, I would appreciate it.
What was but you made a statement, and I want to make sure as well that this is being transcribed, correct?
And if you'll please proceed.
I need to make sure that it's being transcribed because we're talking about my due process violations that I mentioned before.
Certainly.
I need to confirm that it is being transcribed, and I need the transcriber's information.
It certainly is. Ma'am,
Thank
please
you.
proceed.
Okay. All right. All right, so I'm going to it, and I'm going to sit down. I'm going to go into it in great detail. Here you are. All right, so on beginning 10/28/2024, you denied the extension of time as it relates to the Rule 7 transcript. This is in addition to the other due process violations that I've already mentioned. Let's go back. So with regards to your the dismissal order that you entered as it relates to goodwill, I then requested the findings of fact and conclusions of law, which is required for those types of judgments, which you're fully aware, and you denied that summarily without any information. Again, having first initiated email contact with myself and the opposing counsel, that's a due process violation. Then you entered an order denying the extension of time as it relates to Rule 7, and in that order, you purported, which is completely inconsistent with law, you purported, and I can read it verbatim. Go ahead and get them all, 3 of them, because you did this thrice, which actually was very telling because the appeal court rejected your legal analysis because it was flawed, and then ruled in my favor. So you stated that I was incorrect, that the plaintiff was incorrect in petitioning the state tribunal for Rule 7 for an extension of time as it relates to the Rule 7 transcript, and that it must be asserted to the North Carolina Court of Appeals. And that is completely, again, inconsistent with Rule 27C and the standards for the North Carolina Court of Appeals, where extensions, the moving party must first show that they have attempted to get an extension of time through the state tribunal, and there must be a decisioning thereupon before the higher court, the Court of Appeals, can then make a ruling as it relates to that movement's motion for extension. So then having already full knowledge of this, I then reiterated or reasserted my motion for extension of time on 11/4. Then on 11/13, you very oddly and very unlawfully and prejudicially entered a second order, redirecting and attempting to scold myself, the plaintiff, and saying again that I needed to file my motion for an extension of time with the North Carolina Court of Appeals. I then, just for the sake of due diligence, and to literally move an action by the North Carolina Court of Appeals. I then filed that motion with the North Carolina Court of Appeals so that I would get an order thereupon, so that you would then actually comply with the law, and you still didn't. Their response was, I need to do exactly what I just stated, that I must first petition the state tribunal for a motion for extension of time, and I then filed that in this case, and again, and actually goes back further, so your stint of due process violations are so extensive that it goes to the beginning of this case and to present day, because you are actually material. Your due process violations against me are material on my appeal in that case as it relates to goodwill, which is active. I filed my settled record on appeal, and even the opposing counsel agrees with me, ironically enough, in that particular regard. So it's indexed from index 2, after my complaint, because that would be index 1, all the way to index 17. And then so on your third order, again, summarily denying with absolutely no legal justification, denying my motion on the state that it needs to be submitted to the North Carolina Court of Appeals, and not denying it on the basis of actually adjudication on the merits. I then again brought that to the attention of the North Carolina Court of Appeals, and at that point, clearly based on implied by their conduct, they just went ahead and granted the extension of time because of your due process violations and unlawfulness as it relates to just a very procedural standard. There was nothing even remotely, there was absolutely no factual basis at all for your conduct in that particular case. None whatsoever. It was just a procedural task, and I could not even get that completed, and I definitely cannot enjoy a fair trial with you adjudicating. The record is extremely clear. It's ultimate facie justification for your refusal. And anything that you hear today must then be overturned. And I'm pretty sure at this point, because I've already made it very clear that I am definitely cooperating with federal authorities for the criminal prosecution of all judges who are part of this large-scale fraud. I'm very certain whatever ruling you make today, the appellate court will just see that I am just subject to exactly that which I've stated, and everything I've stated, everything I've averred is demonstrably factual as averred.
Let me just ask, if I'm remembering correctly, is this an instance where you had not contracted with a court reporter to prepare it, and that issue was something that should be addressed with the North Carolina Court of Appeals? And I believe that's what I thought was that the issue should be addressed by the Court of Appeals instead of the trial court, and eventually they did address that. No, that's not it. And we have the orders. I can present them to you so you can recall everything that you did. All right. Ma'am, it sounds like to me what your issue is whether or not I decided a procedural issue correctly. I don't find that to be a basis for recusal. I don't find there's a factual basis for that. I don't find there's sufficient evidence to require someone else to address the matter. And so therefore I'm going to deny the motion to recuse at this point.
And I'm going to give open court notice of appeal, and in that regard nothing can proceed until there is a decision on my appeal, because your recusal directly affects my due process rights, constitutionally inviolate. So no further hearing can be held, and you are fully aware of this.
Well, ma'am, I'm going to go ahead and address the recusal issue, and if you want to be heard about that or appeal that, you're welcome to do so, but yes, ma'am.
You just said that you're going to hear the recusal issue?
I'm going to hear that first and then decide what we're going to do next. Yes, ma'am. Yes, ma'am.
Yes, Your Honor. Again, I'm Elizabeth O'Brien from the North Carolina Department of Justice, and I represent Judge Patrice Tennant on May the 8th, an individual identified as Renee McDaniel emailed a subpoena to Judge
Excuse me, Your Honor. You just said that you were going to hear the recusal, and now she's moving forward with a motion to squash. Maybe you misunderstood what you were saying, which makes sense based on what you're doing.
I'm going to hear the issue with regard to the subpoena issue. Motion to quash. Yes, ma'am. If I misspoke, I apologize. Thank you. Yes, ma'am.
Yes, Your Honor. On May 8, 2025, an individual identified as Renee McDaniel emailed a subpoena to Judge Hennett, indicating that Judge Hennett had been served and to direct any questions to the defendant. And then on May 10, 2025, the defendant emailed numerous pages of documents to Judge Hennett, and upon review, none of those documents appear to relate to her or provide any justification for her being called as a witness. On May 14th, Judge Hennett received a FedEx package at her home from the defendant, also stating she had been served. I don't know if you've had a chance to review my motion, but the subpoena has not been properly served. Under Rule 45C5, a court must quash the subpoena upon the showing of any of the grounds in Rule 45C3. First, subsection E, the subpoena is procedurally defective. It has not been properly served. You cannot serve a subpoena by email, so that service is defective, and the defendant herself also cannot serve it, so the FedEx attempted service is also defective. But even if it had properly been served, the subpoena is also objectionable under C3B to the extent it seeks testimony about Judge Hennett's judicial decision making. Any such testimony, testimony.
I apologize. What's the rule number?
For which one? I'm sorry.
The one that you're speaking of now.
45C3B.
All right. Yes, ma'am.
Which states that a court must quash a subpoena upon a showing that the subpoena requires disclosure of privileged or other protected matter, and no exception or waiver applies to the privilege or protection. To the extent the subpoena seeks testimony from Judge Hennett about her judicial decision-making, she has a testimonial privilege that attaches to any of that information. Any information she would have been acquired solely in the course of her official judicial duties. And again, the judicial immunity that attaches to that information also attaches to testimony. And again, it's also objectionable under 45C3C and D that subpoena subjects a person to undue burden or expense and is otherwise unreasonable or oppressive. Judge Hennett's been retired from the bench for 7 years now, requiring her to come in here and appear and testify, and she is here today in light of her retired status, but she has no relevant testimony that's non-privileged to give. Is unnecessary and unjustified. And I wanted to just very quickly address what the defendant mentioned. She said she had not been served with this motion to quash. I did send her an email on Wednesday. Initially, I did send it to the wrong email address. I had a typo in her email address, and it bounced back. I did correct that, and it went through, and it did not return to me. And if she did not receive it, I would suspect it's because 2 years ago in a case I had where I represented several judicial officials, she said she had blocked my email. So if she did not receive it, it's probably because she has blocked my email. But I did serve it by email Wednesday afternoon.
And it's in the portal?
Yes, and I filed it on the portal.
Oh, yes, ma'am. You wish to be heard.
Okay, so again, you cannot lawfully hear any of this any proceedings today, so I want to make sure that is reiterated. So no ruling that you make today would be binding, in that it's prejudicially motivated, and I already expected this, which I informed the court. As it relates to what she stated, I find it very interesting that it appears that opposing counsel for emeritus judge, she is no longer a judge as Elizabeth has stated. She is no longer a judge. The subpoena is devoid of any statement as to that which Elizabeth is trying to incorporate in this courtroom. It doesn't state that I am looking for any type of privy information as it relates to information that she would have when she was in the judicial capacity. Still standing, judges are subject to subpoena. Period. Their judicial immunity does not protect them in that regard. And as it relates to the order itself, is, and I'm referring to her Emeritus Judge Patrice Hennett's order aforetime, that is material in this matter, and the preceding action 13 CVS 8774-120. Elizabeth misrepresents, and that has been her pattern of practice as well. In fact, as she's already stated, she is definitely amongst those who are subject to my federal complaint, valid complaint for injunction against the state for large-scale fraud by the North Carolina judiciary and its co-conspirator attorneys, including, again, namely, Elizabeth O'Brien. And so that's why she was blocked, and that is my lawful right. I don't have to be subjected to any type of harassment, burdensome emails, fraudulently motivated emails, racially provoked emails. I don't have to be subjected to that at all. The court has absolutely no jurisdiction as it relates to my email address. So that was immaterial. As it relates to service, as she's already said, which I find very interesting because she's trying to argue from both sides of her mouth, and it doesn't work. She wants to allege that service cannot be affected by email. Okay, so then that means you didn't serve me. You didn't serve me either. So the subpoena wasn't, according to her, which is not accurate, but according to her, the argument is that the subpoena wasn't served because it was served by email, which is not the only means of service. Then her notice or service of the motion to squash was equally improperly served if her argument were compliant with guiding procedural statutes, which it is not. We'll go to, so as it relates to the seeking disclosure of privy information, again, the subpoena doesn't state that. The subpoena states for her to appear and testify. And whether Elizabeth thinks that she can somehow clairvoyantly know what I'm going to examine Emeritus Judge Patrice Hennett on is completely irrelevant and moot as it relates to the fact that, again, Patrice Hennett is subject to subpoena, and validly so, and a judge can be. We go to Rule 45C3B. And I also want to bring up, because I was able to look at some of the case law, which I find very interesting, because the case law references decisioning by Judge Irwin Spainhauer. And that's been another means by the North Carolina judiciary to harass me in that regard as it relates to the wrongful conviction that I experienced in 2006. So Judge Spainhauer was the presiding judge in that regard. So I find it very interesting, and he's actually subject to the complaint as well, as you can imagine. And he actually has been recused from several matters which he tried to hear, like you're doing in Rowan County. But I'll make sure you're recused finally with absolute finality. 45C3B actually states, because she has no valid argument, but what I was referring to is that particular case law has absolutely no relevance for the subpoena. I pulled it up. That case law is a North Carolina Court of Appeals case, Barb or Bear versus Atwood, and it has absolutely nothing to do with the basis for the subpoena that she's arguing in her knowingly frivolous motion to squash the subpoena. And I can just about imagine that if I were given the proper time to review the contents of the rest of the motion to squash, that I would find that it would be equally frivolous, which it always is. It's always case law that is not relevant, or it is case law that evidently they have had their paralegals look up, and their paralegals have done an insufficient, inept job, because there are always exceptions to rules in case law, and I've learned that in my first year of law school, well before my degree was conferred, that you must read. You must read a lot. You can't just read the first paragraph and then argue incessantly on the basis or the contents of that one paragraph, because there are very, very likely exceptions to the rules or the findings therein, whether it be a statute or actual case law. So when we go to 45C3B, she first mentions that that email service is not proper. As it relates to service, and we'll go to B1, the manner, it reads very plainly. That's the beauty of law, is what I love about it, and evidently that's what the North Carolina judiciary doesn't like about the fact that I am thankfully very cognitively inclined, and I read with comprehension. The language is very plain. It's not like any of the science books I've had to master. And it says any subpoena may be served by the sheriff, by the sheriff's deputy, by a coroner, or by any person who is not a party and is not less than 18 years of age. So number one, my mother is not a party to this case. We can't dispute that. That's an irrefutable fact. Okay? And my mother, we would presume, rational people would presume, is over the age of 18, especially considering that I'm 48. Service of a subpoena, we'll continue reading, service of a subpoena upon a person named therein shall be made by delivering a copy thereof to that person, or by registered or certified mail, return receipt requested. Okay? Service of a subpoena for the attendance of a witness only may be also made by telephone communication with the person named therein, only by a sheriff, the sheriff's designee who is not less than 18 years of age and is not a party or a coroner. Okay? So when we look at this, number one, we have a proper individual who made the service. This subsection of this statute is silent as it relates to email service, and there's case law that references that, and there's also case law that references service by FedEx. Washington versus Klein, which is well-settled case law, so much so that it has effectively become a legal maxim, because the North Carolina Supreme Court and the North Carolina General Assembly would actually goes into great detail about vehemently rejecting litigative sport and reprimanding counsel in that particular case for attempting to engage litigative sport, and the particular act of feigning lack of service, feigning insufficient service. Washington versus Klein goes into great detail with regards to the finding. It says that the rule of law and no particular subsection or nuance of that law should be given more weight than the substantive nature of that law. And then it goes on, as it relates to service generally, that service is deemed affected if the substance of the plain language of the statute is met. And in this case it is. By any person who is not a party and is not less than 18 years of age. Okay? So we've got that type of service. And actually when I issue subpoenas, or rather, let me be more specific, because of course the clerk issues the subpoena. When I assert a subpoena, I effect service both by personal delivery and by certified delivery to avoid this issue. So there was also service by mail.
Ma'am, let me ask you, with regard to the subject of the testimony that you're seeking from former Judge Hennett, what do you have to say about that?
With regards to what?
The subject matter that you wish to subpoena. Why are you subpoenaing her?
As it relates to her knowledge of the cases that follow, not the case that she heard, because the order itself, she can't deny the contents of the order. So I wouldn't need her. It's not logical, if you will, to ask her to examine her on the order, the contents of the order itself. The order speaks for itself. And Emily Meister has violated that order severally, and there's been pattern fraud as it relates to that order. That order, that is not the subject matter of the examination that I am intending, and I've made that very clear because I actually submitted the information directly to her because she's a human. Number one, she's a person. I do respect the fact of her previous judicial capacity, having referred to her as emeritus judge, but she is a retired judge, and she does not enjoy the judicial immunity that has been stated within reason as it relates to agreed, as it relates to any orders that she may have entered in the past. Of course, there's judicial immunity in that regard, but not as it relates to examination, a sweeping privy as it relates to any and all information that she would have, and it is very relevant, and that's why I submitted the documentation for her recall, and that's what the heading of the subject line for the email was for her in that regard, and I find it very interesting that she's moved in this regard. Yes.
Her recall as to the court proceedings?
No, I believe that I said it. I'll say it maybe slowly, more slowly. Maybe that'll help. Okay, so, and maybe I'll read it verbatim directly from the email for you. Hold on 1 second. It was sent to her personal email, which she promulgates publicly, self-promulgated through the North Carolina directory, the bar directory. Give me 1 second. There we go. And so the subject line reads verbatim, subpoena and documents for recall. If I had intended her to subject herself for examination as it relates to her order, then recall, inherently when we do cognitive deduction, I then would have sent her a copy of her own order from aforetime, but I didn't. I sent her a copy of my motion to dismiss, Meister's complaint seeking to renew judgment of a fraudulently effectuated money judgment in the amount of $4,000, for which I not ever had service. I was not at a hearing. It's a very interesting dynamic. And so as it relates to what actually occurred thereafter, the request by evidently Judge Fox to, which I only discovered after I was able to see what they call a legacy scan in Odyssey, because I've been here in the courtroom seeking the court files before, and I had not ever seen this document, and there was a handwritten note by evidently a clerk at Judge Fox's direction, directing the forwarding of the gatekeeper order to all 100 counties, which is a gross violation of North Carolina Superior Court Judges Bench Book 4 gatekeepers, in that a gatekeeper is only material to the county for which it, where it is subject, if it were validly enforced. And so, as it relates to that, and then the affidavit that was presented fraudulently by Richard Huffman in Rowan County, when, ironically enough, I moved for renewal of a judgment in my favor against Michelle Finster Bailey, which had totaled about $9,000 with interest by 2016, and why it's relevant, and why, again, I sent it to Judge Emeritus Patrice Kennett for recall, is because the Huffman, who's now deceased, he actually filed an affidavit, fraudulently padded, misrepresenting that I had filed 162 cases in 72 counties of North Carolina, which is just, it really speaks to his lack of psychological competence altogether, because he asserted that it was in a 2-year stint and that it was related to Emily Meister as well. And let me roll that back because that may be unclear. He doesn't make in his affidavit, he does not declare that the 162 cases in 72 counties that I supposedly initiated, which again is completely falsified and has not ever occurred. But he had evidently, according to his document, he had accessed the statewide case search record or database and entered my name, and then knowingly, because it's very obvious, he then knowingly represented that evidently all these filings that Meister had made in all of these counties, and it wasn't done by a clerk. I've actually had the opportunity to visit several of these counties.
I apologize for interrupting. I think we're getting away from the issue that I need to initially decide, and that is with regard to the subpoena.
Yes, but you had asked, and so I was giving you, it goes into great detail. I can provide it to the court so that you can look at it.
Adequately covered that.
Okay. And then so, may I continue? Oh, I'm not done with my argument. No, if I'm going to be under due process violations, and remember, I know that I need to appeal. We already know. I'm giving advance notice of appeal. We already know that what I'm dealing with right now. You and I, you're looking in my eyes. You know very well what I'm dealing with. And so I want to make sure that all the issues that I raised so the appellate court can know exactly what to do, and the federal prosecutors can know as well. So as it relates to 45C3B, Elizabeth has failed to prove her motion to squash. She has failed to prove that my subpoena is not relevant. It is very relevant to examine and, of course, subject her to cross-examination, because that's what would be most proper, instead of peremptorily knocking out my subpoena as though it's immaterial when it is, of course, material. And the materiality, which we both know is what is actually determined upon proper evidence and examination of a witness, and that's the appropriate time to then determine if the information being sought is privy. But doing it this way is completely unlawful. There's no case law, there's no statute that affords for this peremptory squashing of my subpoena at all. Also, it was served as it relates to Washington versus Khan, as I was mentioning before answering your inquiry as to the information that I am seeking to examine Emeritus Judge Patrice Kennett about. As it relates to Washington versus Klein and FedEx delivery, it has been well settled in law that is actually filed with it. Give me 1 second, I'll read that directly from the case law, and that is actually filed in the case, unlike opposing counsel making bald citations about case law and not incorporating the case law directly into the motion so that it can be examined properly by the court and vetted as actually relevant, which is also part of their pattern and practice of fraud. But in my subpoena, the return of service, I enclosed, attached the Washington versus Klein, which goes into great detail. And in that finding, the court held that the service by FedEx delivery is not only physical service, but it constitutes sufficient service for all service requirements before the court, whether it be for a subpoena or a complaint and summons. FedEx delivery is deemed appropriate, and as long as it is addressed to the proper addressee, it is sufficient. It even goes into detail as it relates to, because evidently the opposing counsel, which is in that particular case in Washington versus Klein, similarly as Elizabeth is frivolously arguing before the court actually ruled upon that as well, that even where the address, the sender, which is not factually myself, with FedEx delivery, they actually require that you have an account, and evidently that is because of combating fraud. My mother does not have an account, so they either asked for your ID, and with my account information, they actually listed that my information as the sender. But according to Washington versus Klein, and having already knowledge of this because I've actually referenced the same case law in one of my federal complaints against Sun Pharma, which also serves as case law that we can invoke here as well. Service was deemed proper because it was delivered personally by a FedEx delivery driver, and that's what the court found was sufficient for physical delivery and thus for sufficient service, period. So there is absolutely no justification whatsoever. All three arguments that Elizabeth has brought before this court, they fail on its face. There's no relevance in squashing the subpoena, again, preemptorily, and I give my advance notice of appeal.
Thank you. All right. In this matter, I'm going to grant the motion with regard, assuming without deciding we have proper service, I'm going to grant the motion pursuant to Rule 45C3, B, C, and D. It appears that this relates to her official capacity. Also, I would find that as a result of that and the information that's been provided to me, I would find it sufficient under 3B to squash the subpoena. I would also find that it is an undue burden and expense, also that is otherwise unreasonable and oppressive. So I would ask ma'am, if you please provide an order consistent with that, if you would please serve that on the opposing party, pro se party. There is a local rule in my judicial district with regard to submitting an order submission form. She should have 10 days to respond to the proposed order. Any written submission that you have should go to opposing counsel, and that should be submitted to Mr. Robbins. So thank you very much. What I would ask, I've got a number of other matters that I'm going to need to address. I would ask that you all come back at 2 and we can address the remaining issues in the case. And ma'am, you're released.
Your Honor, for service on the defendant, she admitted she has blocked my email address. How shall I serve her with that?
All right. Ma'am, do you have an email? Do you wish to receive it?
No, absolutely not. She is still blocked and remains blocked and shall forever remain blocked.
Oh.
I was going to actually address that, but I thought maybe it would be addressed. So everyone else who's ever...
You hold on just a moment.
Can you answer?
If we have a physical address, you simply mail it to her.
That's exactly what I was going to mention. I find it very interesting that the intent has always been to harass me. And that's by the email. So, but with my mail, which is very interesting because she should be serving it by mail by law because I'm not yet licensed, so I don't. There is no requirement that I keep an email address with the court at all.
If I could just stop you just one moment. What I'm asking is, how should she send it to? If you want it mailed to her, what address should she mail it to?
She has my email. She has my mailing address. It's on record. Everyone else has mailed. And I've received it. I do not refuse service. I've not changed any lack of service, and it is a virtual provider, and so I receive it in real time, and that's how she needs to serve me. Period.
Your Honor, one further request. Judge Hennett, I told Ms. McDaniel this in the email that she blocked, but I asked her to stop making personal contact with Judge Hennett because she is represented, and I would like to ask the court to also order her to stop personal contact with Judge Hennett.
Oh, yeah, well, you can't do that. That's not lawful, and I have no reason to contact her if the subpoena is squashed. This court has absolutely no jurisdictional authority through a motion to squash to then order me. That's ridiculous.
One moment.
That is absolutely ridiculous.
Just hold on just a moment. So if you wish to provide anything related to this case, if you'll provide it to the AG's office with regard to her, I understand she does not want you to have personal contact with her. I take it that is correct. That's what you're...
I find that very interesting. Your Honor, so let's be very clear. I sent out a subpoena. And I then sent out, and I want to make sure this is on record as well for appellate purposes and for the federal prosecutors, because this is exactly what I needed to see. I needed to know exactly where people stand. And now I have my answer.
All right.
As it relates to the subpoena, I have absolutely no reason to...
If you talk over me, we're going to have a contempt hearing, and you can be jailed for 30 days and fined up to $500. So, ma'am, when I'm giving you instructions, you'll need to talk. I understand that if it relates to the official hearing in this matter, she's represented by counsel. You should contact counsel that way. With regard to her individually, I understand she's expressing in open court through her counsel that she does not want to have contact with you. I understand you to say that's all right with you. Is that right?
I'm sorry?
Do you want to have contact with her?
I find it very interesting. And again, when you respond, you have to understand that I have to also get an opportunity to respond. So throwing out contempt is also a due process violation because that doesn't give me an opportunity to actually... So the court reporter, the recording is taking down what we're saying. To make a proper transcript, if there's over-talk, that makes it difficult to be transcribed. But you're over-talking me when you ask me to respond to a question. Right, ma'am. Because I don't normally do that in normal life, but here I need to give instructions. So to hear my instructions, when I start talking, I'd ask that you stop, and then I'll be happy to hear from you in the response to that. So and I have stopped, but then when so it doesn't. It's like a double-edged sword because we know that it's not being wielded. It's being wielded prejudicially. What I was trying to explain to the court is I think it is absolutely delusional that even Judge Patrice Pennant would think that I want to have any personal contact with her because I would have done that prior to. If you stop when I start talking, ma'am, you don't have to talk about people being delusional. All that is inappropriate in the courtroom. She's asked you not to have contact with her. If you need to contact her through related to this case in official proceedings, you can contact the AG's office. I'm going to ask that you all come back at 2. Thank you very much. Yes, because it's not an order. There can't be an order as to that regard because that's unlawful. Thank you very much. All right. So we will resume this at 2. I believe we had anybody?
Now, if we can return to the Meister versus McDaniel's matter, you all please consult. All right, according to the docket, it looks like there's a motion for protective order, a motion to dismiss, a motion for judicial notice, a motion for correct case designation, and a motion to continue is what is all listed here. So the plaintiff, and it looks like there's also a motion for summary judgment, I take it.
Yes, Your Honor, there's our motion for summary. The motions that we have pending are our motion for summary judgment and then the motion for protective order as it related to discovery. Those would be the motions that we have pending.
So your motion for summary judgment, does that fully resolve the case?
It will fully resolve the case.
And if that fully resolves the case, then a motion for protective order would be moot?
I believe so, Your Honor. That would be our position.
All right. And ma'am, you have, it says a motion to dismiss, a motion for judicial notice, motion for case designation, and a motion to continue. Is all that correct?
Yes, that's correct. The motion to continue, of course, would take precedence because it's to continue this particular hearing. And I'm renewing my motion for recusal as well, so I'll be asserting that here momentarily. This proceeding cannot go forward. My due process rights have already been grossly violated at this point, and it should be disturbing to even you who have been subject to the recusal. It's judicial candor just shows that there's a huge issue with the judiciary, especially as it relates to me. It's very clear that there's a infinitely disturbing prejudice as it relates to me, and it's very telling because, again, the federal prosecutors have already, that's why they're willing to take my case. They've already seen that it is very evident because the evidence is stacked against you all, especially as it relates to pattern fraud. That's the quirky thing about pattern fraud is that it actually stacks the evidence pretty finitely. And so, again, I'll be renewing my motion for your recusal. And again, the motion to continue is necessary as it relates to my motion to dismiss. In the particularity that the gatekeeper enforcement, of course, we know is in bad faith. We know that. We already know that. You know that. Everybody knows that. And I have been disallowed from actually filing. You seem disinterested, but justice should interest you. Whether someone's black or not, it should interest you. But yeah, so for my motion to dismiss, the gatekeeper order has been wielded to prejudicially, summarily deny just the filing of documents, and all I filed was a memorandum of law in support of my motion to dismiss. And it was denied for filing, against which I had filed a notice of appeal. We know that interlocutory appeals are valid, number one. They are also appeals by right, number two. And we know that when they affect due process rights, then the hearings, the proceedings thereupon need to, or not upon the appellate matter, but upon the fundamental case from which it stems, they need to be stayed until there is a decision by the appellate court. So we now have at least 5 pending appeals as it relates, my 5 pending appeals that are still valid. I'm very certain they'll cook up some more frivolity as it relates to motions to dismiss appeals, and we can do this, and we shall, because I am very, very apt, and I shall continue to fight for justice, even in my death. I've already made plans and arrangements with individuals who are going to continue on this fight, and even in your death or their death, criminal liability attaches, especially as it relates to public interest and public policy, and this is definitely one of those type of cases with the unlawful enforcement, the unlawful effectuation of a gatekeeper order to basically serve this fatal blow to a subject party with the intent to deprive them of their equal protections under the laws. And so posthumous trials are very, 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 very common. And then the civil liability that can be assessed to a deceased person's estate, including yours. And so that will be the intention. So whenever you're ready, I can proceed on my motion to renew, my renewed motion for recusal.
Go right ahead.
Okay? Oh, it looks like he wants to say something.
No, go ahead. It's your opportunity. If you want to say something about recusal and the motion to continue, I'm happy to hear it.
Okay. And may I please have his card?
We'll take care of the details of that now. If this is your motion to continue and your motion to recuse, I'm happy to hear what you have to say. Please.
May I please have the transcriber's card? I have done nothing disrespectful in that regard. I'm just asking for the transcriber's card.
You're happy to have that at the end of the matter, but right now we're going forward with our motion. This isn't the time to do that. If you want to be heard about your motion to continue and your motion to recuse, I'm happy to hear what you have to say, ma'am.
Normally, I'm able to get the transcriber's card, so I add that to the long list of due process violations against me as it relates to, and I don't find any of that funny, Your Honor.
I don't find it funny either. If you please stand when you address the court.
You didn't ask me to do that before, so I need full directions. You didn't ask me to do that before, so I need full directions so that I make sure, because that's another part of the reason for my renewed motion for recusal, because you are wielding your contempt power in a manner that is completely prohibited by the court of law. So when would you like for me to stand, and I'll write that down, and when would you like for me to sit, and I'll write that down, so that I make sure that I'm not violating your now off-the-cuff contempt rules. Please.
Rule 12 of the Superior and District Court rules provide counsel at all times are to conduct themselves with dignity and propriety. All statements and communications to the court shall, other than objections and exceptions, shall be clearly and audibly made from a standing position behind counsel's table.
All right.
That's the rule.
All right. So I will stand when addressing you. All right. I didn't have to do that before. I'm going to make sure that's on record that you didn't request that.
I didn't request it because it's required by the rules.
I'm sorry?
I didn't request it because it's required by the rules.
Oh, okay. Well, it seems like it would have been necessary to remind me if I had forgotten of something during the entirety of that hearing. I find it very interesting that also the emeritus judge just yelled and disrupted the courtroom and then stormed into the chambers as a retired judge. There's no jurisdictional authority that allows her to do that, especially being subject to subpoena. And as it relates to service, I want to make sure, because this is also a due process violation, which is in reference to my renewed motion for recusal. Again, Your Honor, I find it very, very interesting that you think that this is funny. I have been subjected.
Ma'am, let me just interrupt you. Mm-hmm. I'm not laughing. I'm not smiling. I'm listening patiently to your argument is what I'm doing, what I'm trying to do. Mm-hmm. And I've asked you to address those two issues, and that is your renewal of the recusal motion as well as the motion to continue. So if you'll tell me the substance of those motions, I'll be happy to hear from you. I'll hear from opposing counsel, and then I'll make a decision.
Mm-hmm. So substantive to that would be the court's demeanor, and you are smiling. Even my son noted that, and when we were here earlier, he was wondering why is the judge laughing at you?
I'm not, ma'am. Just let me just say, mm-hmm. I'm certainly not laughing at anyone. This is my responsibility to sit in the middle and listen to what you all have to say. That's what I am trying to do, mm-hmm. and I'm happy to hear what you have to say. If you can move forward with the substance of your argument, I'm happy to hear what you have to say, and I'll make a judgment about it.
Okay. And again, substantive to that is your court's demeanor. And that exactly, you have laughed several times, you have smiled several times, and that is not, that definitely exceeds or at least meets the appearance of partiality. In addition to, let's keep this in mind, in addition to the entirety of the record for the case against Goodwill and Concord Police Department. None of this is proper. Now, I am aware that I have the lawful right to vehemently reject the continuation of these proceedings and just walk out. I know that I have that right. I also know that it is very necessary for me to raise issues so that I preserve them on appeal. So that's the reason why I'm staying, and that's the only reason why I'm staying. As it relates to my renewed motion for recusal, we've already addressed the fact that the due process violations that I have presented to the court initially, which now you recall, but you evidently recall in a different rate, although the record is pretty finite. I can't obfuscate it, you can't obfuscate it because the record is finite. And it says what it says, and it means what it means. In that regard, my recusal motion is solid. It is substantiated, and again, there's an ultimate case sheet justification for the same. As it relates to the court's demeanor, that is also relevant, and that is it breaches the appearance of partiality, and also subjects you to valid recusal. Furthermore, in the North Carolina Superior Court Judge's Bench book, it states, and actually this was also filed with the court in the case as it relates to my motion to recuse you in the case 24 CBS 000821-120 against myself, plaintiff, against Goodwill and Concord Police Department. And this matter is being transcribed, correct? Okay. In that Superior Court Judge's Bench book, again, which is filed with the court and it's invoked, when contempt is actually being wielded with the intent to suppress and oppress a movement's due process rights, that include hearing rights, then that contempt power is being abused, and that judge is subject to disqualification as a matter of law, not just mere recusal, because in that actually far exceeds the mere appearance of partiality, and the movement then is entitled to a recusal hearing before a judge who is indifferent. And it's very clear that based on your demeanor, your decisions in the case 24 CBS 00821-121, and in this case, and even suggesting that you could enter an order that would prevent me from somehow being able to communicate with Emeritus Judge Patrice Pennant, when the law, especially as it relates to the filings that I have to present here in the near future as it relates to criminal liability, because it's very evident that she is also a co-conspirator. I've gotten my answer today. In that regard, it requires personal service, just like it requires personal service on judges as well, even not only in their individual capacity, but in their official capacity. And so she will be served at her address of record again, and I would imagine that she's going to stir up some dirt, but that's how the service goes. That's the law. That's the law that you all entered into, and that's the law that you are enjoined to as well. And in that particular regard, everything that has been done, even if we don't even incorporate all the due process violations that you have committed against me and now are feigning to not remember, which are so voluminous and so specific, and even feigning the nature of it is what you're attempting to do. Feign the nature as if it was some legitimate adjudication and some legitimate interpretation of procedure, statutory procedure, when that was not the case at all. And it's very clear from the record, and again, the record speaks for itself, res ipsa loquitur, there is absolutely no way that you can continue with this proceeding without it constituting a gross violation of my due process rights, and on appeal, any and all of your rulings will be overturned. And I'm confident of that.
Thank you, ma'am. Just let me say so it's clear.
Do you want me to continue standing?
No, ma'am.
Okay. Just make it.
If you'll just follow the rule, that would be helpful. Ma'am, what I want to make sure you understand is I didn't order you not to contact Ms. Hennett. Generally, what I said was that she does not want you to contact her. She's requesting that.
No.
And with regard to contacting her with regard to the case, she's represented by counsel, so you should serve anything on her counsel or communicate through counsel with regard to this case is what.
Your Honor, in response to that again, because this will be an issue that will raise on appeal, that would actually have no bearing. You have no jurisdictional authority in that regard, so your comment, even as to her request somehow to speak at me directly, person to person, was completely improper.
Thank you. Yes, sir.
Your Honor, do you want me to address the motion to recuse?
Yes.
Again, my name is Keith Black. I'm here on behalf of the plaintiff, Emily Meister. Your Honor, I do not see anything that you have done today, for sure, that would justify recusing yourself from the case. You have appeared to be very patient. You have not raised your voice. You have tried to explain to Ms. McDaniel the rules and what you're asking for. You asked her multiple times to answer questions, but then she goes someplace else and you have to redirect her. As far as what happened down in Cabarrus County, it does not appear to be anything that, again, would cause recusal. So I would just echo and ask you to make the same decision that you made earlier today when you were dealing with the motion to quash the subpoena, that we're here and we're ready to proceed, and we would like to proceed on the merits of the case.
Thank you.
Okay, and of course, I definitely have a response on that, again, as it relates to issues on appeal. First of all, he has no dog in this fight as it relates to Cabarrus County, and the fact that he would even interject in that regard is absolutely also a show of impropriety, and it just actually is, it's an act in the furtherance of their pattern conspiracy and fraud against me. It's very evident. He, of course, this issue of refusal and not having you recuse yourself, which you should do as a matter of law, and under the operation of law, you are now disqualified, whether you acknowledge it or not. The operation of law is such that you are disqualified by operation of law. It is completely improper for him to even assert himself as it relates to Cabarrus County, because he has absolutely no knowledge. No knowledge. Zilch, nothing. As it relates to his purporting that I have somehow needed to be redirected and answered, that's also inappropriate, because none of it is accurate, whether or not you've been patient. There are very, very belligerent people that are very, very calm and stoic as well. I've seen in my history as law enforcement with Park Ranger, the National Park Service, I've seen very stoic individuals who have a glaring stare and who seemingly, from the outside looking in, they look to be calm and collected, but they are very, very criminally minded. So whether you were feigning or projecting patience and he observed patience is completely moot and has absolutely no materiality as it relates to the very real fact that my son saw you laughing so much that he commented to his mother as to why is someone laughing at his mother who has a doctorate and a JD. And we should be here for justice. That should disturb you in and of itself. That should make you pause as it relates to your behavior and your candor towards me. We know that the judicial canons are very, very clear in that regard. Of course, they're not going to take notice of that because they have actually engaged even worse behavior. They were outside laughing and joking as me and my son were leaving. So I do not expect, there is absolutely no expectation. And based on my pleadings, there would be absolutely no expectation to expect Meister or Black to admit their wrongs, to admit their behavior, or to co-sign or to be truthful as it relates to the analysis of the judge's candor toward me. So it's completely without materiality, has no basis, he has no dog in this fight, and you are validly subject to recusal as a matter of law and disqualified by operation of law based on all of the due process violations that you have committed against me willfully. We both know willfully.
Thank you, ma'am. Let me say, I appreciate you all bringing the issue to my attention. I consider the motion. I find that it has no merit. I'm going to deny the request for recusal. Say, ma'am, I'm doing the best that I can to be fair to both you and the other side, to sit in the middle and listen to the case, do it in a patient way, try to understand your arguments. I'm doing my best to do that. You may not perceive it that way, but that's what I'm trying to do, trying to be fair to both you all and apply the law in a fair way. That's what I'm trying to do. That's all that I'm trying to do. This is not personal against anyone. I'm just trying to come up here and hear these matters, and that's what I'm doing my best to do. So while you may have some disagreement with decisions I've made or will make or haven't made, I'm doing the best that I can, and if you disagree with some of the decisions I make, there's a process for that, and you can follow through on that. I'm denying the motion to recuse. I find it's without merit, as I did before. I don't find it rises to the level that someone else needs to hear the motion to recuse. I find it's without merit. If you wish to be heard about your motion to continue, I'm happy to hear that.
Your Honor, as it relates, again, for issues raised on appeal, you made mention in your finding. I would imagine you would assert that it is. And foremost, let me also make sure that it's very clear that I'm giving my open court notice of appeal against, or from, rather, your open court order denying recusal. And in that regard, this hearing cannot validly proceed because it constitutes yet another due process violation, and there needs to be a decision on whether or not you should be recused, which we know you should, and disqualified before there should be any other action taken on in this case, especially as it relates to adjudicative power and contempt power and my hearing rights. As it relates specifically, and then I'll move on to the motion to continue because, again, I'm already familiar with the patent fraud, and I've been taught very well by Dean Jolly. I'm very excited about my Juris Doctorate learning, and I've been trained with great composure, so I'm good to go in that regard. As it relates to the statement that you made that it doesn't rise to the level of recusal, that's not what North Carolina Superior Court Judge Bent's book says, nor does the constitutional law, U.S. Code 28, Section 455, and I believe there's 3 other sections that speak about the disqualification of a judge. It says specifically, shall. It's not under discretionary authority. It is a mandate. So it's not a matter of it rising to the level. If there is even the appearance, and the case law, the statutory law is well settled in this regard. It is not about a matter of it rising to the level of something that the judge who is subject to recusal considers himself to then be valid or constitute recusal. You are subject to recusal under shall.
All right, ma'am, I've made my decision with regard to that. If you wish to be heard with regard to your motion to continue, I'm happy to hear what you have to say.
With regards to my motion for continuance, and you have it before you?
If you filed it, it should be available.
Yes, that was filed.
All right. What date did you file?
Give me one second. May 16th.
All right. Yes,
it would be indexed as 40.
Yes, ma'am. Go ahead.
It was indexed as 42.
All right. Yes, ma'am. What would you like to say about it? Okay. Give me 1 second.
I just want to make sure I'm looking at the same one. It's date filed May 16 at 12:24 p.m.
Is that right, ma'am? I'm still looking for it as well.
I have 12:24 and 30 seconds p.m. May 16th.
There's also an amended order, excuse me, hold on 1 second. Let me make sure that I'm speaking informedly, because I had a amended motion, and I'm not sure if it was, yeah. So I filed a motion for continuance, and maybe that's what he's referring to. I'm not sure of the relevance of his seeking clarification. But assuming...
Ma'am, if I could just stop you. I'm just trying to figure out what document we're looking at. So if you could help me with that. You said one filed May 16. Is that not it?
So, again, in response, because I'm responding directly, and incorporating him standing up and asserting clarity on April 28th, I filed the initial motion to continue. And that index is 35. So I would imagine maybe that's why he's seeking clarity. And then it's not noted as such, but it is an amended motion to continue on May 16th, which we know by law then replaces the first. So there should not be any issue with clarity. And let me make sure that I'm looking at these, because I have filed, and so basically, so that it gives you factual background. There was no ruling on my motion to, okay, so let me give you factual background very quickly. The opposing counsel filed the motion for summary judgment, which is before the court now. But when scheduling that, they did not regard my availability in violation of Rule 6, which is a pattern for them. I've already explained that to the court. It's well documented. In fact, so much so that they had actually filed the motion, scheduled the hearing on the same day, and hadn't even noticed me. And it was scheduled without any regard for me at all. And that's the norm for opposing counsel and his client. Okay? So then I moved for continuance, because again, I'm very apt in asserting myself. I'm not ever going away. I'm going to make sure I get full justice, and it will be unmitigated, and it will be glory, so much glory. So I filed the motion to continue, which they always hem and haw as it relates to the gatekeeper order, and try to, obfuscate this and that. Then it was finally filed, okay? Because of course I have to get a judicial order allowing the filing. And for whatever reason, this court thinks that I can't file things on my own, which is absolutely absurd. So then it filed, which is, ironically enough, even in the district jurisdiction, they have me file the stuff. But for whatever reason, the Superior Court thinks I can't file into the e-filing system, which I do on a regular basis, very competent, overcompetent. I have no issues with making sure that it is clear to the court. I think I've already made it clear to the court. So then I believe it was Brittany Robbins who then reached out to Keith Black to ask them if his office was going to actually voluntarily reschedule it, or if she needed to make a ruling on my motion. And I may be, thinking was it she did that as it relates to me filing the second motion to continue. And then I can say that they did take Keith Black through his office, whomever he directed, or if he did it himself, I'm not really sure. But opposing counsel collectively pulled it from, they rescinded their scheduling, and then they still didn't communicate with me as to conferring on a date as it relates to my availability. They never take any regard, and they always use the excuses like Elizabeth did, that they can't email me. When ironically enough, I have communication with attorneys all the time who just send me mailings, and I answer the mailings. It's very simple. It's child's play. In fact, my son can do it. He's 15. He can do it. He's helped me out with things before he's supposed to be working with my future firm, and he does a fabulous job of the very simple things that opposing counsel doesn't seem that they can undertake. And so in that regard, then I received another notice from them, again, scheduling this hearing without regard for my availability. And ironically enough, in the email feed with Brittany Robbins, including opposing counsel, because I believe it was first scheduled for May 5th, it was scheduled prior to, and then she gave the options of May 5th and May 19th as dates, and I made it very clear that I had a May 5th hearing, which I did. I had a trial in Wake County, and I responded in that feed, making sure to inform everyone of my availability, and they still scheduled without regard for my availability for May 5th. And like I said, then Brittany Robbins stepped in and said, hey, are you going to take this off, or do I need to make a ruling? And then they once again, only at her direction, not at my request, they then rescinded that, withdrew their motion for that particular calendaring, not withdrawing their motion altogether, of course. And then it was scheduled properly for May 19th because I said I could make it available. If anything, I could definitely make May 19th. And so hopefully that clarifies everything, but I just feel like that was just, that's the frivolity that I'm talking about. None of it was relevant.
So you're not asking to be continued because it was set on today's date?
I am. I'm saying the frivolity in asking for clarification. He knows what he's done.
Right.
I'm
Why are you asking to be continued today?
Are you ready for my argument now?
Yes, ma'am.
Okay. Thank you. All right. And I was asking if you now see it because okay, perfect. Okay. And we're looking at Index 41, May 16th. I'm just making sure you seem annoyed.
I'm not annoyed. I'm looking at it. You're asking me questions about this that, with regard to how it's indexed. I can tell you that what I have in front of me is what purports to be a motion to continue that was filed on May 16, 2025 at 12:24 and 30. 12:24:30. If that's what you're asking me, if I have that in front of me, I do.
I'm only bringing it up to make sure that there's no more issue about the clarity.
It doesn't matter to me why, with regard to that, your answer to your question is yes, I've got it in front of me.
Okay. All right. All right. And in that, I say that in that the binding legal authority that governs gatekeeper orders strictly prohibits the gatekeeper order for the purpose Meister, Black, and Reuter. I'm not sure if Reuter is any longer with their firm, but Jennifer Reuter, these are individuals from the beginning. The case from which this matter stems, 13 CBS 8774-120, intended and how Wood is manipulating it. And thus the filing of my May 10th memorandum of law cannot lawfully be denied from just filing. Memorandums of law are procedurally basal. There is absolutely no justification for denying just the filing of my memorandum of law, especially where that memorandum of law is invoking case law, binding legal authority, statutory. So we're not just talking about case law, we're talking about statutory, binding law, legal authority in that regard. And when briefing is expected, because my motion to dismiss without my memorandum of law is just a leading document. It has there's no legal reasons, and that's very common. You're fully aware of this. That is very common for litigators. I'm not a layperson, even though I'm not licensed. We know I'm not a layperson. Even beyond the lie that I filed 162 cases in 72 counties. I've not done that, but I've definitely got litigative acumen. And in that regard, we know that it's very common to file a leading document for your motion and then to brief that, and then it would be considered fully briefed when both parties brief their motion on the moving side And on the respondent side, they then respond in opposition or respond generally, and then file a memorandum of law in support thereof. It's very straightforward. There's nothing unusual. There's no language in it that's inflammatory. There's nothing. It is literally it is a continuation of exactly that which that I have petitioned in this frivolous renewal action. And I can also clarify the motion for case designation, because that actually is now resolved. The clerk resolved that. And I imagine that it was definitely opposing counsel who orchestrated the improper case designation to expose me to criminalization and further vilification. But I'll clarify that in a second here. And I had also filed when he denied just the mere filing of it. I want to make sure this is very clear. Denying just the mere filing of my memorandum of law in support of my motion to dismiss, and considering that the documentary evidence that is presented in my memorandum of law, its ultimate facie justification. It's a slamming hammer, and it shows exactly what all they've done, and there's no way to get out of it. There's no way to get out of it whatsoever. That the initial judgment that I didn't know about for $4,000, because the initial judgment that I knew about was for $1. And evidently they went back in, and I'm speaking colloquially now. When I say they went back in, I'm pretty sure you understand, but I'll clarify. They then effectuated with the same judge who is subject to the foremost act of constructive fraud, Carl Fox, after Judge Hennett had made an order vacating the gatekeeper order at issue in 2013, and actually making very clear stipulations that this court, nor any judges, nor any attorneys, nor anyone on that side should retaliate against Ms. McDaniel, because they've already done so, to the extent there was even times where I would try to just come into the building and whatever they had orchestrated, and this is noted in Judge Hennett's order, which I find it very interesting that evidently she doesn't want to be involved. But in that regard, I wasn't even permitted to enter the building, which is a huge due process violation.
Ma'am, so if you could sort of direct me back to the reason that you're asking that it be continued.
This is relevant to the reason. Please understand that the nature of this, and we know this about oral argument, whether it's in the trial tribunal or the appellate court, that's the whole point of it. This is not one of those cases where it can just be explained in 2 or 3 minutes. So it's so complex.
If I could just make sure I understand.
Yes.
Your basic reason for wanting to continue is because a gatekeeper denied your request to file a brief. Is that right?
That is generally, yes, the substantive component of my motion. And then as it relates to Wood's May 14th order denying the filing of, and if you don't mind, I'm going to refer to it as an MOL. The MOL, of course, then constitutes a gross due process violation. In response, on May 14th, I submitted my notice of appeal therefrom. And again, we're in the same situation. You all can't just keep, because my mother always says, why do they keep doing this stuff when they can't? And of course, I'm using can't very loosely because of course, you can, but of course, you're not the end all be all. That's just fact. There is a higher court. Yeah, you're not.
I believe I understand your motion. It is essentially that he filed an order that disallowed you to continue, or rather to file this brief, and then you have filed some sort of notice to apparently the Court of Appeals challenging that. Is that correct?
Some sort of a notice. It's an appeal by right from an interlocutory order that directly, detrimentally affects my due process violations.
Thank you. All right. Yes, sir.
Yes, Your Honor. I'm going to try to just narrow it down to exactly what the real issue is. The motion that she filed on May 16, 2025 is her motion to continue it because Judge Wood would not allow her to file a memorandum of law. Memorandum of laws are not filed with the court. They are handed up. If you look, Your Honor, a few days after she filed her thing on, actually at 12:39 on May the 16th, there's an amended order. Your Honor, I made a copy of all of the filings that are in this case. I'm happy to hand up that I may be able to more quickly direct you to where it is rather than you having to go on that thing. And I have a copy from Ms. McDaniel also. If that would make things easier, I'd be happy to hand those up.
And you know I'm going to object to that because they are not reliable in that regard. I've asserted that. I've shown that to the court. I don't need a copy of the history of the case when I have the case records and you have the case records through Odyssey. I object vehemently to him presenting some type of his own record of the filings. You have the records in Odyssey. And that is the prevailing standard. Nothing that he would submit that hasn't been filed and indexed would be relevant. And that's the point here as it relates to my memorandum of law, which rule, if I'm not mistaken, and I'll look it up to verify, Rule 28 does require that a motion is fully briefed and that those briefs be filed. A brief, because that makes sense, the same way you would have an appeal. You don't just send an informal brief just to the opposing counsel. Of course, the reviewing court would need to see the informal brief because they would need to rule upon it. They would need to decide. So a memorandum of law shouldn't just go to counsel because that is not commonsensically fundamental. It makes no sense. You would need to see that also, even if it was just proper in the court of law.
Interrupting my argument because
I'm permitted to.
All I ask is whether I could hand this up or not.
Let's go one at a time. What I'm going to do is I'm going to, as a courtesy, providing me a copy of that, I would appreciate. You can provide a copy to Ms. McDaniel. Ma'am, if you see there's something wrong about what's being submitted, it's just merely my convenience because it's quicker to look at the documents that way than to flip through the system. That's common what I did earlier today when folks had judgments. I said, do you have a paper copy of it so I can look at it before it's sent to me? Those sorts of things, it makes it easier. So if you don't want to accept a copy of it, that's fine. But if you would like to approach to provide it to me, I'm happy to.
So again, I object, and I don't receive it because it's not reliable. And that's the reason why there is Odyssey, and that's why there's been the integration, and this also constitutes a due process violation. You're asking me to review this in a matter of whatever time, because I would like to get back down the road before I have to actually be in the middle of Charlotte traffic, Annapolis traffic. That would be great. That would be awesome.
I respect that.
That would be awesome. And you have it there. All of it, that's the whole point of it being indexed, and respectfully, because I'm not sure, now this I think would be editorializing, so I won't say it.
Thank you.
But the point that I was going to make here is that
let me just say, I understand what you're saying. I understand it's right here in front of me. I can do that. It takes an enormous amount of time. If I've got it in front of me, you can look at it if you'd like. If you don't want to look at it, that's fine too. But I think it's appropriate that for a matter of convenience that I have this. If you want a copy, they'll provide it to you. I understand you're saying you don't. So I'm now going to hear from this gentleman.
I do have one other objection, Your Honor.
What's your objection?
My objection again is the relevance as it relates to the motion to continue. There's no materiality in him presenting the entirety of his physical copy of the case record. And again, I bring the attention to the court that that's the whole point of Odyssey integration. The mission, in fact, is for more access, transparency, and in every other court that has the integration with e-filing, and it may not be something that is comfortable for you. It is definitely part of my age in education, if you will, not engaging ageism, just so you're clear, because I am 48. I'm not exactly a spring chicken, but that's why they are there. I'm literally pulling them up myself in real time, and then that way there's no confusion, because I don't want to have to be off the cuff referring to things and then you disbelieving, because we already see that there's due process violations, and again, this constitutes one, with me trying to cross-reference whatever he's pulling up, and then the fact that he was trying to get clarity. This is the same frivolous litigative sport that the North Carolina Supreme Court has prohibited for years, and he's engaged in it. There's no relevance. It's a motion to continue, and I find it very interesting because we just clarified my motion to continue and the reason for it. And then he stands up and he says, I think I can clarify the same thing that we've already said. So I'm finding it very interesting that the court doesn't want me to be duplicative, but he's being completely redundant and it's immaterial.
Yes, sir.
Your Honor, I will set on the table copies of the documents just in case there's an issue. If you look at tab 40 of what I handed up to you, Your Honor, that is the motion that you were referring to, that is May 16th, 2025 at 12:24 p.m. And that is where Ms. McDaniel indicated that she wanted to request a continuance because she was not able to file her memorandum of law, and also that she intended to appeal that. If you turn to the next tab, which is tab 41, you'll see that she actually filed a notice of appeal on May the 14th, 2025. And it's as a result of her being denied the right to file her May 10, 2025 memorandum of law, which, Your Honor, I would say is an interlocutory appeal. It does not divest the court of the ability to hear this case today. I have a case, Your Honor, that I can hand up to the court that I, of course, can give also to Ms. McDaniel that indicates that interlocutory appeals that do not affect the substantial right, they are not, the court can move forward with the case. I then also would ask that you look at tab number 43. On May the 16th, 2025 at 12:39 in the afternoon, there was an amended order in which Judge Wood indicated that it denied the request to file the above referenced submissions, which was the memorandum of law. The defendant is on notice that the memorandum of law and exhibits referenced above may be brought to court for review by the presiding judge during the notice motions should he or she so choose to do so. So His Honor made it clear to her that you're not being barred from being able to present it to the court. You can present it to the court today.
And so, of course, I have argumentative.
Your Honor, and so I do have a series of cases that I have printed out for today. Again, I'll leave a copy with Ms. McDaniel. I'd ask if I could approach it.
Yes. All right. Thank you. Yes, ma'am. Let me just start by asking, do you have a copy of that memorandum?
I do.
Okay, you want to just provide it to me?
I can. It's 500 pages.
That's fine.
Sure. Okay.
You want to provide that to the bailiff?
Yes.
You all received a copy of it already?
Yes, they received it separately.
We have never received a copy of the memorandum.
We can go one at a time. There's no reason to rush. I'll give you all every opportunity to talk. You have a separate copy of it that you can provide to me.
That is part of the issue, Your Honor. I am a new doctor and a new JD. I don't have the attorney money like everyone else. I am indigent, proceeding indigent in this matter, and I made that also clear, which is also part of my motion. So me printing this out was already, as you can imagine, 500 papers, and that was part of also my contention.
Would you do me this favor then?
Yes, and that's why, sorry.
Please show it to opposing counsel.
Sure. Yeah. But that's why I emailed it, and I have proof of the emailing. Even where he is blocked from emailing me, they have been including me in...
Well, if you just do me a favor, provide it to me. Then take a look at that.
that they have several copies. And there's even more. So that which, what I tried to do in the interest of, because that was my...
Hold on just a moment. They're looking at that. They can't look at that and hear you talk at the same time. So let's do it in a orderly fashion.
Do you mind if I step out and use the bathroom? I came straight back. We have an issue with getting back on time, and that way it gives them a little time. Is that okay with you?
Why don't we take 5 minutes, 10 minutes?
Okay,
That'd be fine,
great, because
yeah.
I've not had a chance to use the bathroom.
We'll be in recess.
Thank you. Thank you.
Do you have any other documents that you are saying that you want to provide?
No, I have five binders. I do take issue. I'm going to allow my son to stay here, and he'll watch. He's a fierce warrior, but to make sure that they don't tamper with evidence. But I do have 5 binders here.
We'll take 10 minutes and come back and do the whole thing.
We're not, Your Honor. I wish that we were in a place. I would really wish we were.
Thank you, Your Honor.
We have some parts of it.
No, we didn't.
Hey, this is Keith. Can you give me Amanda? It was sent to them. It supposedly would have been sent to us.
Amanda said there was a group of links. She didn't need you to send that email when Brittany...
Hey, the memorandum of law that she wanted to file with the court, we never received a copy of it, right? We never received the amended counterclaim defendant's memorandum of law in support of her motion to dismiss and exhibits L through U. All right, can you forward that email that you got from Brittany that shows that it went to Brittany and them, but not us? Oh, thank you. Gosh, you're so. Yeah. Okay. All right. Thanks. Okay. Bye. Supposedly it's here. She made copies for us. Looks like this set of emails, see if that's the one. And here's another set that Brittany provided to me.
So Keith, this step on what I see is there are filings from the faxes from other matters, not ours. You know, like how computer accuracy are particular not accurate. Then there's a portion of the transcript that's in from other matters. It's not an official transcript.
That's it. Access to overdraft. Compressed policy. It's not really there's a fourth file in my
Here's my amended memorandum of law. This is from Tigress where the only reason we have this is because Brittany copied this when she was filed. But we didn't get the money. Yeah, but it's not us. And she's like,
Okay.
that's children.
That's what I needed. We can get it. That's in Wake County. I don't know what that has to do with anything. Other than we're probably sued in there, aren't we?
I am, but I didn't even know this.
Okay. Right. Okay.
That's just not okay.
I'm upset.
No. I don't know what these are.
No.
Yes, Your Honor. In reviewing things, we've been able to determine that on Monday, May the 12th, Ms. McDaniel sent an email to Brittany Robbins, Stephanie Wallace, I will not say her name right, Chenacone Bennett, and included, please receipt and forwarding to the proper judge of my amended MOL, which I assume is a memorandum of law, for the purportedly merited pre-filing review. We were not included with that in that email. We never received that email, and we never received the memorandum of law. We've had a chance to glance at it. Your Honor, I think we'd have the right to object to it being submitted to the court, but in looking at what's in there, most of the things appear to be filings that don't even relate to this case, including a case that she filed evidently in Wake County in 2023, in which she listed Ms. Meister as a defendant, to which we've never received any notice, never been served with it, and it may or may not have gone up to the Court of Appeals. But there appears to be a bunch of stuff that's not related to this case. So for purposes of moving forward and trying to be able to get through with this today, we do not have an objection for that memorandum being submitted to the court. I would ask that she be required to serve us with a copy of it within 24 hours. And then, Your Honor, if we feel like that there is something in looking at it in greater detail, that I will advise Ms. Robbins and ask the court to give us a chance to argue about it. But for purposes of moving forward, if that will be acceptable to the court, we certainly would rather do that than delay the court in some manner, shape, or form.
And of course, how would you move forward? The notion is ridiculous. How would you move forward on their motion for summary judgment and even my motion to dismiss if my brief is not being properly considered? It can't be considered in part just because you want to. It is a briefing. It is well settled in law.
If I could just stop you for a moment. I understand they don't object to it being submitted to me. They don't object to my considering it. They don't, if there's something in there that when they go through it in more detail, when they have more detail to review it, since it wasn't sent to them according to them, then within 24 hours it will let us know, and I would give you all another opportunity to be heard about it. Satisfactory to you?
It is not, Your Honor, because again, my degree actually entails psychology. And so my biggest...
Let me just say this. So the way this typically happens is if I get a brief, I typically don't read it until after the hearing, because what happened initially when I was a judge is I could have a back seat full of notebooks when I roll out of town or roll in that people send to me to read. You get there and those cases are resolved. So what my practice generally is, unless I absolutely know what's going forward, and you very rarely do that, is I typically would take the case under advisement, review any materials that folks have submitted, and then issue a ruling after I've had an opportunity to do that. So that's my normal process.
I am familiar with that process as well. Again, I want to make sure that the court is fully aware that I am not a layperson, and I understand why you're intending to communicate that to me. However, it is still a due process violation in the fact that, for whatever reason, there's case law to support the fact that it is a due process violation. A leading document, which is all that's called.
So let me ask you this. They're saying they don't object to your submitting to me what you want me to consider. Is that okay? Do you want to submit your brief to me to consider?
I don't think you're understanding. That's not the substance of my objection. That's not the substance.
That may be, but I need you to answer that question for me. Do you want to submit your brief to me?
I feel like I'm being taunted.
No, I'm not trying to hide the ball. I'm not taunting you. I'm just asking you simply, do you want to submit the brief that you say you were not allowed to file? Do you want to submit it to me to consider right?
Clearly, yes.
Okay.
But I want it.
May I have a copy?
I want it in its entirety. I've stated this before the court. I'm not sure if you don't immediately recall, that I could not print out the entirety of it. I would have loved to. I spent a great deal of time once I learned that he would not allow for the filing. I spent a great deal of time printing out what I could.
I'll take whatever you have.
But that's not sufficient. That's not a due process. Again, that's not regarding my due process rights to just take a couple of things. I submitted a full briefing, and that full briefing goes from, it is, like I said, it's about 500 pages, and each one of those, everything that I intend to proffer as evidence, each, especially as it relates to their motion for summary judgment, even where they will likely argue that it has ancillary relevance, is what I expect them to argue, as it relates to the specificity of the judgment for sanctions and the money judgment attached to that for $4,000 that I was not ever aware of.
Ma'am, if I could just say, looking at the order, it says, defendant is on notice that the memorandum of law and exhibits referenced above may be brought to court for review by the presiding judge during the notice motions, should he or she choose. So I'm telling you, if you have the memorandum of law and exhibits that you want to submit to me, I'm happy to take it, in whatever form you have.
All right, and so again, Your Honor, again, for raising issues on appeal, this hearing cannot go forward as it relates to that, because that is a due process violation. When we're talking about substantive due process, I think you're thinking maybe just a procedural due process. I can't submit to you everything that I intended to submit to you because I could not afford to print it out. That nature of being indigent and not having full opportunity like everyone else, because this Constitution in this state and the prevailing Constitution gives me access.
Would it make you feel better if I say you can simply email it to the court and to counsel, and I'll be happy to consider whatever you submit? Doesn't that cover it for you?
It doesn't, because I already did that, Your Honor. And that was the next part of my argument, is that I already submitted the entirety of my MOL to the opposing counsel, and they purport that, and I don't think it's a willful act, it's not just a mere purporting. They purport that they didn't receive it because there was a reference thereto in the emails, in the feed with Brittany Robbins as it relates to my MOL and the motion to continue. Because again, remember, he's now repeated what we've already repeated, that my motion to continue hinges directly upon the due process violation and not just allowing the filing of the entirety of my memorandum of law, which I intend to proffer as evidence in support of not only my motion to dismiss, because the MOL very concisely states that it's in support of my motion to dismiss and in opposition of their motion for summary judgment and in support of my pending motion. So we can't just flippantly say, okay, we're going to just, whatever she sends, we'll take a look at it. I am completely not confident that you will actually read the entirety of it, and I am asserting my rights to an oral argument and asserting my rights to hearing rights to actually have it in the file, so I know at the very least that there's the transparency intended by the integration of Odyssey, because if we're not going to follow the rules of the North Carolina General Assembly, then we need to all pack it up and go home. That's it. We all need to pack it up and go home. That's the whole point of the electronic integration. It's for transparency to curb constructive fraud by the court and curb constructive fraud by anyone else, any parties in the case. That's the whole point of it. I'm not sure why this court, and well, I have, of course, my suspicions, but in every other court before Wake County, even as it relates to me being considered like a lay person in comparison to licensed attorneys, Judge Eagles has required a brief. Judge Duncan, no, not Judge Duncan, Judge Sasser has required a brief, very specifically, in fact. Judge Walton, Judge Brown, Judge Julie Bell required a briefing. All of them required it. And I agree where, like I said, I am very familiar with the fact that there is the opportunity to take it under advisement. But my biggest concern, Your Honor, is that when I concurred with that, there are implications for me when I raise issues on appeal. And I won't allow that as it relates to my due process right. And once that occurred, please allow me, because I need
Ma'am, I believe I've heard from you with regard to this issue. I understand what your objection is. I understand that you have copies of the brief, but not full copies of the brief. I understand you have an electronic copy of the brief. I understand all that. I understand that you objected to the matter going forward because you filed an appeal with regard to Judge Wood's decision, saying that you can't file it electronically, that you can bring it to court. I understand all of that. I understand that's the basis of your argument to deny, or rather to continue the case.
May I, Your Honor, because there's one part I don't think you're understanding. Whereas, and this is actually well settled in the case law as well, Deborah Sasser, I submitted to her similarly a briefing at her request. And most, again, in the courts that I've been before, they all require it to be filed. Otherwise, they don't entertain it. And they require that it be timely submitted to the opposing counsel, which I did. And I understand that you're allowing for it to be presented. But here's my concern, is that when Deborah Sasser took it under advisement, I know you're not Deborah Sasser.
You just stop. I'm telling you, if you submit it to me, I'm going to review it. That's just the way I do it, not just for you, for every case that comes in front of me. That's the process that I follow. If someone takes the time to write something, I'm going to take the time to look at it. Unless hearing the case in open court, it's absolutely clear that there's something that the ruling needs to be made. Then, but if you, and I'm going to take it under advisement under these circumstances, I'm going to give you 24 hours to submit it to them and to the clerk again, who will provide it to me. I'm going to give them 24 hours from then to respond in writing to you and to the court if they wish to be heard further about it. Since they're telling me they don't have it, you may well have sent it, but they're telling me they don't have it. So that way, it's all in front of me. That's what I intend to do. Is there anything further on that?
Yes, and if I would be allowed to finish my sentence respectfully.
Sure.
Okay. So Deborah Sasser, and I know that you're not Deborah Sasser, but here's the concern. We do know that you are Judge Martin McGee, and that you've already committed due process violations against me. Whether you agree or not, it's already on record. It's well established. None of this proceeding is lawful. And I am not confident that you're going to properly consider the entirety of my briefing in support of my motion. Absolutely not. Why would I think that when you're not even willing to just defer recusal to another judge when you know that you cannot be a judge in your own cause, and you understand when there's a detrimental effect to due process rights, then that's what you need to do by law, and it says shall. It doesn't say may. Here's the other concern.
Ma'am, I've given you an opportunity to be heard about that. I understand you're telling me your feelings about what's going to happen with regard to whether or not I'm going to review it or not. I've heard you on that. That is my decision. I'm going to allow you to submit it to them within 24 hours and to me. Any partial motions any partial documents you have you want to submit to me, I'll be happy to take them with me and consider them as well. I am denying the motion to continue. I would find this an interlocutory appeal. It does not affect a substantial right, and we're going to move forward with the plaintiff's motions. I'm going to hear your motions, and then I'll decide the case.
So, and that being said, my motion to dismiss would take precedence over a motion for summary judgment, and I'm very sure you're aware of that, but I also give open notice of appeal from your order denying my motion to continue because it's unlawful.
Thank you. I'll just ask if you'll just have a seat. I determine the order of the hearings. I want to hear the summary judgment motion first.
Your Honor, just to allow Mrs. McDaniel to feel that you had every opportunity. We do not object to her arguing about anything that's in that memorandum of law today to you. She wants to refer to it, if she wants to cite to it, if she wants to point it out to you and walk up and let you look at it, if it's actually where they can pull it up and you can look at it, we don't object to that. I'm only asking for once we get a chance to actually look at it, if we feel that we need a chance to be heard. So I am not trying to limit her in making any argument to you today about any of the issues that are before you.
Thank you. If I can hear your motion for summary judgment.
As it?
Yes, ma'am. You have it already? All right.
Yeah, they've had it. He has it, Your Honor.
Your Honor, I'm sorry. I'm tired of her saying that I'm misrepresenting things to the court. I'd ask that there be some instruction that cease and stop.
Let me just say about this. I understand what she's saying, that she sent it to you, and I understand what you're saying, that you didn't receive it. I'm not here to resolve that issue. And frankly, the information is going to be provided right now, and we're moving forward. And I'm happy to hear.
That I appreciate, because I've done it several.
Ma'am, I appreciate that as well. If you'll have a seat, we're going to hear the motion. Thank you.
I thought you'd ask me to stand.
I've asked you to follow rules.
Your Honor, first, and just for purposes of in order, the first thing that we filed was actually the motion for the protective order. My understanding is you would like me to address the motion for summary judgment first.
Yes. Well, because I understand that if that motion is granted, the other motion's moved. Am I correct about that?
Yes.
So it seems to me that would be the appropriate order. I hear that motion. I hear the motion to dismiss. If we're moving forward, then I think it'd be appropriate to hear.
Your Honor, again,
Your Honor, I do object as it relates to issues on appeal. It is well settled in case law and statutory procedure that a motion to dismiss needs to be heard before a motion for summary judgment because of the nature of the motion to dismiss. And it is not the jurisdictional discretionary authority of the judge to decide the order of the relevance of motions, especially when you're talking about a motion to dismiss as opposed to a motion for summary judgment. And my motion to dismiss was filed in December 16, 2024. Their motion for summary judgment was just recently filed. And I have incessantly requested for a hearing. incessantly. And I find it very interesting that they, as we saw, and that's, again, on court record, it can't be disputed. All that it took for them to get it calendared was for them, without any regard for my availability at all. All they did was submit it to the court and it was
I'm
calendared.
just going to stop you. I don't have anything to do with the calendaring of the motions. They're calendared as they are. Understand your objection. I'm overruling it. I'm using my inherent discretion to determine the order of arguments, the order of motions. Thank you. Yes, sir.
Your Honor, I was going to agree with Ms. McDaniel. She did file her motion to dismiss. It actually was November 30th, 2024. We filed our motion for summary judgment on March 27th of 2025. Your Honor, if you go in the notebook that we provided to you, if you go look at tab 18,
Yes, sir.
okay, you know, that has our motion for summary judgment, and attached to the motion for summary judgment is the affidavit of Ms. Meister, in which she basically indicates this, that back in 2014, the lawsuit actually was filed in 2013, but in November of 2014, there was a gatekeeper order that was entered, and it is attached to, as Exhibit 1 to her affidavit, and it's actually Exhibit 2. Exhibit 1 is the one for the monetary damages. The gatekeeper order is attached as Exhibit 2, and that order was entered by the Honorable Judge Fox on November 25 of 2014. Exhibit 1 to Ms. Meister's affidavit is an order that was entered and filed with the court on April the 27th of 2015, in which the court sanctioned Ms. McDaniel in the amount of $4,760, and judgment was entered against her for that amount. So there are two portions, two different orders that our complaint that we filed in November of 2025 address, and that we are asking the court to extend those judgments for the 10 years as allowed by law. If you look at, and I have included, and I believe it is under tab 10 in the book of cases that I handed up to you, and it's and Ms. McDaniel has a copy of it. I gave her the notebook. It is the Unifund CCR Partners versus Loggins case. It's a 2020 case. If you turn to page 3, it just indicates this: an independent action seeking to effectively renew a judgment must be brought within 10 years of entry of the original judgment, and such renewal action can only be brought once. So the rules to renew a judgment are that it has to be filed before the 10 years of the judgment expires. The judgments that we filed our complaint, Your Honor, I believe about 10 days before the first order that was entered in November of 2014, the gatekeeper order. We filed it on November 21, so we filed it 3 days or 4 days before the entry of the gatekeeper order, and 2 or 3 months before the entry of the 2015 order, actually 4 months, because it was April of 2025. So we filed these. Ms. McDaniel shortly, actually, I think that I've already pointed out to you, on November the 30th, filed her motion to dismiss. And in the motion to dismiss, she alleges that it should be dismissed by a knowing malicious fraud after plaintiff wielded sewer service fraud to obtain summary judgment against J.D. Plaintiff was not ever justly entitled to summary judgment nor any subsequent money judgment. So her answer and response to our and it was a verified motion, a verified complaint, Your Honor. It's also a verified affidavit by Ms. Meister, is that we should never have been able to obtain those judgments to begin with. As Your Honor is well aware, that if she wanted to attack those judgments, you attack those judgments by appealing those back in 2014 and 2015. She goes on in her motion to dismiss, and Your Honor, this sort of, obviously I'm dealing with the motion to dismiss at the same time, because I just don't see other way, because her answer is her motion to dismiss. She goes on to ask for a jury trial. In light of the case that I cited to you saying what we have to do, I don't believe there's any issue of fact or any issue of law. It is, the issue of fact would be, did we timely file? We did. And then the next thing is, have we done it before? No. So this is just, and then the issue of law is addressed in the case I gave you. This is how we do it. And so we would ask that you enter a judgment that, number one, preserves the gatekeeper order for an additional 10 years. And that, number two, you enter judgment for the amount of the $4,000 some odd plus interest as allowed by law, and that we move forward and go home. It's really that simple on our motion for summary judgment.
Thank you very much, sir. Yes, ma'am.
I'm actually glad that he made those statements in open court. So this further helps in the fullness of my justice. So the first thing we're going to address, because now it is relevant based on the fact that he brought it up. It's very interesting. Very disturbing. Very disturbing. There are gatekeeper order laws in place about which Meister nor Black can feign any type of lack of apprehension. They can obfuscate, but as licensed attorneys, they are expected to understand the plain language of the law, the basic law. There is absolutely no law that stipulates that a gatekeeper order can be entered for a 10-year period. That's number one. Also, there is no judgment ever in 2013 as it relates to the case from which this stems, the 13 CBS 8774-120. There is absolutely nothing in that order that even remotely says that the gatekeeper order, and this is by, I guess it would have been November 2014, I believe it was, nothing in that order that states that a gatekeeper order has been entered against me by Carl Fox for a period of 10 years that can be renewed for another 10 years. The notion is ridiculous and absurd. There is absolutely no basis in statutory law nor case law for the enforcement, the entry of a gatekeeper order for a 10-year period and then for subsequent renewal thereafter. And I'm so glad that he stated that on record, because that's exactly what I presumed that he was trying to do. And the clerk of court evidently agreed with me in that regard, because when I moved, this brings us to the motion for case designation to correct it. There is no such cause of action to renew gatekeeper order. There's no such thing. It doesn't exist at all. He just made that up to criminalize me and to vilify me even more through their pattern constructive fraud. And let's be very clear about something, because he wants the court to somehow keep me from talking and saying things that he doesn't agree with, because of course it then exposes them further. At this point, the exposure is just, it's like it's the same offense. I'm a Southern Baptist girl. It's the same offense as having your slip showing in the church when your skirt is coming up. It's reprehensible. Okay? That doesn't exist. Like I said, the clerk of court agreed with me, and they changed the designation, because what they actually had on the designation of this case, because again, that motion was presented to the clerk, not to the judge, and it's very clearly asserted as such. And the case designation, as Meister and Black submitted it, was for a permanent restraining order. So we know that also is prohibited by the gatekeeper orders. The fundamental nature of the gatekeeper order is such that it cannot be permanent, and that it within the gatekeeper order, it must include, shall, not if you feel like it or if the judge wants to do it. It must include a modification option, period. There's nothing in gatekeeper laws that even remotely gives them the unchecked power that they are trying to wield through this jurisdiction. It doesn't exist. And excuse me, because it causes pause, because it's just that disturbing. Okay? That the North Carolina Superior Court Judges Bench Book, it's a cheat sheet. It's like 7 stipulations, or maybe 10, but they're one-liners, they're one sentences, and they're not even like long run-on sentences. This is stuff, again, my 15-year-old understood. So a licensed attorney cannot easily defend against understanding that. And it very clearly says it cannot be for the purpose that they want. You can't put a gatekeeper order in place to subserve an unjust disposition against them and advantage so that you can win cases. You can't enter a gatekeeper order against someone effectuated by fraud, by constructive fraud. Lies. Defamation, we know, it's a very, very clear thing that an absolute defense to defamation is the truth. And that's what we're talking about. I'm not name calling. I'm telling the truth. And the truth has been suppressed over the years, and that's why I find it very interesting, again, that Kenneth thought that it was necessary to squash the subpoena. It's very interesting. Very challenging. But again, I'll happily move forward with criminal prosecution against her as well. Anyone and everyone who's involved. The gatekeeper order cannot be renewed because it was not ever entered on the basis that it would be for 10 years and permanent. That's not how that. You look at the order is there. It speaks for itself. Even though that order by Carl Fox is completely fraudulent, it doesn't exist. It doesn't exist as far as the stipulation that this gatekeeper order would be entered for 10 years. Doesn't exist. So the clerk of court then changed it because I explained to them that if anything, because I'm very objective. As a scientist, that's the first thing, but a good scientist is always objective, even to their own fault. So I admitted to the clerk of court, hey, now that evidently they got some type of sanctions against me that I was not ever privy to. They committed sewer service fraud, to which, mind you, Carl Fox makes reference to. Now he misrepresents, of course, that, basically I had opportunity, even though he states that there was an issue with her. He then follows up and says, well, she had the opportunity to show up in court. Like, I'm just supposed to clairvoyantly know that there's another subsequent action filed against me. And keep in mind, from 2013 to present day, I'm a public figure. I'm a politician. So I'm not in hiding, even though they have made, oh my gosh, the smear campaigns that they have put in place have just been absolutely ridiculous. And I'm talking about as it relates to Meister and Black as well. As it relates to the 162 cases in 72 counties, which is extremely relevant, and that's the primary basis of my brief. It goes into great detail and it shows how that same lie was then copycatted from county to county in 4 counties to get a gatekeeper order against me. And you can, in the last gatekeeper order by Anthony Burks, in this constructive fraud, this large-scale constructive fraud, because I am an anti-corruption politician, as you can imagine. Very notable in that regard. Very effective, very efficient in that regard. They have orchestrated this criminalization of me in hopes that they will make the general public not believe in my efficacy. So that's why they call me Queen Get Her Done. So in that...
Let me ask, with regard to your motion opposing your motion for summary judgment, if you want to include in that arguments about your motion to dismiss, I'm happy to consider them as well, and I'll give them an opportunity to respond to that.
Okay. All right. So with and that's why I was referring to the fact that the motion for correction of the case designation is no longer, it doesn't need to be heard by the court. It not ever did, except, of course, I was definitely, when you talk about the court and the clerk, of course you're talking about interchangeably used.
You're saying that motion's moot.
Was resolved. Yeah, right. So I don't want to necessarily call it moot, but it's been resolved because the case designation has been changed to reflect that it's for sanction and not for a permanent gatekeeper order, because there's no such cause of action at all. It doesn't exist at all, not under North Carolina law, and for that reason, it would have to be dismissed in and of itself. That's the foremost. He's arguing that even where the case designation has been changed, because that is the premise of their entire complaint.
Just so I'm clear, what you all are asking is that the money aspect of that order be recorded against her. You're not making a comment about the gatekeeper order.
Yes, we are asking that the gatekeeper order be renewed for an additional 10 years.
In this particular case?
In the 2024 case. We do not believe there's any other mechanism we can do it. There's not any case law, Your Honor, that we could find in North Carolina that deals with a permanent injunction gatekeeper order. So out of the abundance of caution, we elected to file this action to ask that the gatekeeper order be extended for an additional 2 years, because as a judgment, it appears that it may end at the 10 years. And so we're asking it to be extended, and there's other reasons.
All right. I understand your request. Thank you. Yes, ma'am.
I understand where you're asking the question for clarity, but it saddens me in this regard, because he's telling on himself, and it's like you're giving him options.
I'm going to stop. I'm not interested in your commentary about things saddening you. I need to know the basis of your argument, not your commentary about whether you're saddened by his argument and those sort of things. Those are simply not helpful to me. If you want to argue your motion opposing the summary, if you want to argue your motion to dismiss, I'm happy to hear that. I'm happy to hear any arguments you have opposed to the motion for summary judgment, which I've been listening to.
I'm not saddened by him. I didn't say anything even remotely like that. I said I'm saddened by the disposition of the court to continue to favor anything he says. He can say it's the sky is blue. If I say the sky is blue, then you question me.
I'm just let you know, I don't know why you would say favor. I'm asking for clarification. Just I want to ask you questions for clarification. I don't know what I'm going to do in this case. I'm going to listen to what you all have to say. I'm going to review the material you have, and I'm going to make a judgment. That's what I'm here to do.
Okay, so it's very clear now. Then this side, the opposing counsel, is seeking a renewal of a gatekeeper order for 10 years that was not ever entered for 10 years, because it can't be entered for 10 years because there's absolutely no claim for relief under North Carolina law for that. And he's also admitted that, but then he claims that he's doing it out of an abundance of caution, which is completely frivolous. If I had filed something like that, I would have been vehemently scolded. They would not have allowed me to file it at all, because it is not a valid claim for relief.
And I see you're standing. I'm just going to simply ask you, if you'll complete your argument, I'm happy to hear what you have to say about whether or not the motion for summary judgment should be granted, whether or not your motion to dismiss should be granted. That's what I'm here to do.
Okay. And this is why this should not continue, because it's a due process violation. My rights are not being regarded at all. And so we've cleared up the ridiculousness of a gatekeeper order being entered for another 10 years. It doesn't exist. So on that basis alone, and finitely so, with that being the basis, the premise of their complaint, the complaint has to be dismissed, period, because there is no claim for relief for the renewal of a gatekeeper order, which they purport had been entered for 10 years. It was not ever entered for 10 years because there is absolutely no law that supports that at all. None. I have, during the entire course of this 10 years of dealing with this, have been, and you are well aware, as you're also even more so informed in this court, we know that I'm not abandoning any appeals, and I'm not. And there's a 10-year statute of limitations for constructive fraud. And the discovery rule applies. So every act of fraud thereafter, in the furtherance of the object of the conspiracy, it extends that time clock. So that time clock is real. That time clock is statutorily binding. And that's why I'm not saddened in that regard. It's not sad. That actually stacks the deck on the more, I get more and more money damages with every act that they commit in the act of their pattern fraud. Now, as it relates to that portion of their motion, it's dead in the water. Done. As it relates to the sanctions, when a order is effectuated by fraud, and in this case, we're talking about judicial fraud by false files. And the record shows it. So this is not some defamatory, inflammatory statement. This is fact. Fact. Because Judge Hennett's preceding order, was to vacate and modify the initial preliminary gatekeeper order that had been entered. Let's keep in mind, Your Honor, I'm not sure if you're aware, but we'll make sure you are aware because it is relevant to the motion to dismiss and their motion for summary judgment. You see, the interaction between myself and Meister began with Meister assaulting me and Alexandria Strickland. And there's nothing to object because that's in Carl Fox's order.
I'm going to object to...
That's in Carl Fox's order.
Yes.
She is now talking about things that occurred before the judgment and judgments that I'm asking to be extended. It's not relevant to the issue.
Ma'am, I'm going to hear from you as well, but I don't want you to interrupt. Okay? Yes.
It's not relevant to the issue that's before the court today, which is our complaint sufficient and is this motion for summary judgment appropriate? What she wants to do is she wants to attack, and her motion to dismiss is attacking the underlying judgments of Judge Fox. She had a remedy. She could appeal those. She didn't. She had a remedy about whatever happened in 2013. That's long since gone. We're talking now about the renewal of this judgment that we have now. And so I object to her just going on about things that are before the judgments that we're talking about.
I find it so interesting. As a scientist, this is what helps me out so much in law. It was such a great starting point. I didn't think it would be, but it's an excellent starting point. Because my specialization is wetland bioremediation. So I'm always looking at the finite. Always looking at the details. And you see, so what he's presented to the court is a knowing lie because he's a licensed attorney. I'm not yet licensed.
I'm going to ask you not. I'm going to ask a knowing lie, and it's not the type of conduct not the type of language we use. If you say he's factually wrong, you think that he's incorrect, that's fine. In terms of a knowing lie, where we are right now is he has an objection. You're going behind the judgment or behind the order, attacking that, saying that's not appropriate in this form. That's what the objection is. What is your response to that?
I am already well aware that I'm responding to it. And so the court must, under my due process rights, allow me to respond to it. And you'll see the relevance in it. This is not editorializing. I'm not just touting my expertise. I'm telling you why. I always say that it's buried in...
If you will address my question to you. His objection. You wish to be heard by his objection.
I thought I was. I thought when I continued, my answer is yes. That's why I continue to stand. My answer is yes.
Good.
Buried in the statutes is a term that I coined. Post-conviction, post-judgment relief, either one of them exists. Laypersons, only laypersons are those licensed attorneys who are trying to obfuscate the law for their benefit unlawfully. They hold out that once a judgment is rendered in the district court, it's final. That doesn't exist. Once a judgment is rendered in Superior Court, it's final. That doesn't exist. Once a judgment is rendered in appellate court, it doesn't exist. Once it's decided in Supreme Court, even for the North Carolina Supreme Court, that's not the end of it either, at all. Depending on the matter at hand, the subject matter, and we're talking about constructive fraud. So I have the privy, and he's giving you the impression that I didn't appeal. I have appealed. They know very much so that I have gone through the appellate process and that I have post-judgment relief that is in place right now. Right now. Part of that, of course, is, which I not ever lose that right to. The core part of that is, and this is referring to their objection, is on the gatekeeper order itself. So I have renewed my motion to vacate the gatekeeper order. And I won't stop renewing it because there is no law that allows for me to stop renewing it.
I'm going to sustain their objection. Ma'am, if you wish to be heard about your motion to dismiss, I'm happy to hear what you have to say about it. But as it relates to the issue before the court of renewing this judgment, whether or not, if you want to respond to their motion for summary judgment, whether or not the essential elements are met to renew a judgment is one thing. The other thing is there's some other basis that you have for dismissing it. In addition to what you've already said, I'm happy to hear what you have to say about it.
So let's read it. I wanted to make sure you're done.
I'm done.
We're going to read it because again, being respectful to the court, we're going to talk about rules, and this is definitely part of it because we're talking about statutory law. So we know the statutory law takes precedence over case law generally, right? Well, of course it does. Okay? So, summary judgment, there are requirements that need to be met. And this is what I was referring to as it relates to my background as a scientist and the details. It's very good at the elements, proving up the elements. They have completely failed in proving up the elements for summary judgment. They're very, very finite, you see? One second here. So number one, there must be no more facts that are in dispute as it relates to the judgment that is subject to being renewed, right? In this particular case, that's what we're dealing with. Because you have motion for summary judgment that applies for other causes of action. But in this particular case, we're talking about renewal of a judgment. So this is why you can't just sweep the 13 CBS 8774 case under the rug, because that is the basis for the judgment that was entered back then that they want to renew. The sanctions thereupon that they effectuated in fraud without me being present, ex parte hearing,
I'm going to sustain the objection that he previously entered, that he previously made. Well, I know what the standard for summary judgment is. I know what that standard is. The issue is whether or not there is a genuine issue of material fact as to whether or not this should be renewed, not about whether or not the prior judgment should be set aside. That would be an issue for another day.
No, so you have misperceived. I have not stated that at all. There is a manner to be able to argue upon the materiality of that particular case and the judgment thereupon, which they're seeking to renew, without seeking you. I'm not seeking you to overturn that judgment. I got that under control. I'm on top of that. I'm on top of that, Rose, is what they say. I'm on top of that. I don't need your help in that regard. What I do need your help in.
I'm not offering my help to anyone. I'm sitting in the middle trying to listen to your arguments and their arguments and make a judgment about the matter.
And that was, I just mentioned that colloquially. If you recall, again, was trying to be respectful to the court, even though the respect has not necessarily been given to me.
Let me just interrupt you there, ma'am. I'm doing my very best to listen to what you have to say and what they have to say, being respectful to each of you all, making sure that we're, however, going by the rules. That's all I'm trying to do.
However, Your Honor, you keep assuming that I'm saying one thing without allowing me to finish my sentence, and then you interrupt me, and I'm being respectful because, again, we know that you have threatened me with contempt, which is unlawful, for the purpose that you're using it. And so that's the reason why I am making sure to bring it back, the focus to the statutory law. So for the element for a motion for summary judgment, again, no genuine dispute of material fact. Again, this has to be on the judgment itself. The judgment itself, in looking at it now, because I didn't have the privy, my rights were not regarded for me to see it back then. Seeing it now, there were sanctions that were entered against me that they moved upon. They moved for sanctions, and their co-conspirator, Carl Fox, said, okay, we're going to enter these sanctions, even though there's a service issue, and that those sanctions were entered in the amount of $4,000, I want to say $200, something to that effect. Okay. That was derived in constructive fraud. So if there is a derivation or an adjudication or the judgment itself is predicated upon fraud, then no, there can be no summary judgment for renewal of sanctions that were obtained by fraud. That kills it, dead in the water. There's no option. And that's the reason why I have incorporated that case, the particularity of that judgment in and of itself. It doesn't exist. So they're not entitled to a judgment as a matter of law. They're not entitled to that because it was effectuated by fraud in the first place. They're not entitled to that. There is no supporting evidence as it relates to even the sanctions or the summary judgment thereupon which they're asking for in this renewal. Because we're talking about a renewal of a judgment, again, that was effectuated in fraud, and mind you, on the basis that I used the word, in fact, I noticed from the legacy scan, which is laughable, and it's an embarrassment to the judiciary. I use the word, and I'm an etymologist, self-proclaimed. Saw that smile. And in that regard, I use the term that she is, and I'm referring to myself, that she was monomaniacally focused on me, obsessed with me. Obsessed. That term, it's literally in the filing, and that was the basis for their summary judgment for sanctions and getting $4,000 awarded to them. Even the notion is ridiculous. But again, I'm not arguing the appealability. I'm not arguing my post-judgment relief because I'm on top of that. What we're arguing is that there are still material issues of genuine dispute of material facts as it relates to the renewal of that judgment in and of itself, that it was effectuated by fraud. Furthermore, as it relates to my motion to dismiss, when you have, and give me 1 second because I do want to invoke, now these have been filed directly with the court. And I would ask, as I'm looking for this, are you intending to just look at their submission to you, or are you going to look at the filings in the court record? Are you going to compare and contrast them as it relates to when you take this under advisement? Even though, again, we know that I'm appealing the judgment if it is not proper.
Ma'am, I'm going to review the materials that are submitted to me and make a judgment about it. In terms of the detail level I'm going to go through, each document by document is going to depend on the circumstances of the case. So I'm still open-minded about what you have to say, and I appreciate it if you will continue.
All right, Your Honor. Sorry.
Your Honor. I've asked your question. Yes, ma'am.
Are you going to review the actual filings in the case?
I'm going to review everything that I think is necessary to make my judgment. One way or another.
That doesn't answer my question, Your Honor, and I'm not being facetious because the issue I presented before the court, we already...
Ma'am, if you will continue your argument in terms of how I'm going to approach the case, if you all have submitted information to me, I'm going to review it. That's what I'm going to do.
Are you going to review the filings in the case? Because they take precedence. Are you going to...
Anything that you point out to me that you think I need to review, I'll consider doing it.
Okay, absolutely. So let's point out every last filing that I made, because that's what's relevant. Thank you for clarifying. So number one, my motion to dismiss in lieu of an answer as it relates to their case.
You don't need to go through and tell me each individual document. I'm going to review what you think is pertinent to the case, what they review is pertinent to it. I'm going to evaluate that during the argument and review the information I think is necessary to make a decision.
Your Honor, that's not consistent with due process. I'm not going to read them verbatim.
Just if you will I'm going to give you an opportunity to continue your argument with regard to why it should be dismissed. If you refer to documents that you believe are relevant for that, I'll be happy to take it under consideration.
Okay, but so I remain completely not confident that you're actually going to review that which I filed. The reason why that's relevant...
I really don't need your commentary about that. You've said what you've said with regard to how you think I'm going to do my job. You're welcome to have your opinion about that. I can just simply tell you I'm going to do the best that I can to be fair to both sides and make a decision. I'm going to listen to your arguments. I'm going to consider the things that were submitted, and I'm going to do my best to be fair to both of them.
I've not ever heard a judge not just definitively say, yes, I'm going to review the file in its entirety, and that's it. And that in and of itself is very telling. Number two, so my index 3 is, sorry, let me go back. Number 5 is so index 6 is my motion to dismiss. Index 7, my motion to strike my defunct birth name from the case record, which was denied for filing, and by Wood. I believe that was also index 7. Index 8, my notice of appeal, as it relates to the order denying the filing of the motion to strike my defunct birth name, because it has no relevance as it relates to this. In fact, my birth name was changed in 2004.
Ma'am, I just don't really understand why you're telling me these things, as they don't appear to relate to your motion to dismiss or their motion for summary judgment.
It does. Sorry, Your Honor, it does. It speaks to the frivolity of this action. Frivolity is also a basis for dismissing the action, and you told me that I could also argue, well, I know that I can, whether you tell me or not, but you said that you would hear my arguments as it relates to my motion to dismiss, and they're relevant thereupon. Motion, let's see here. My answer as it relates to Emily Meister's motion for protective order and objection to the first set of interrogatories, which I requested, and she still hasn't complied. Compliance is still required, whether you move for a protective order similarly to the motion, the subpoena that I had issued against tenant. It didn't absolve her from not appearing. The motion had to be ruled upon, and even though it was ruled upon unlawfully, it's still required.
I'm going to sustain that objection, and I'm going to ask that you move on to things that are relevant, or I'm going to say your time is up.
Okay, and I'm going to give a notice of appeal as it relates to that as well. These are relevant to my motion to dismiss because...
I'm telling you, at this point, I'm the one that decides what's relevant. In your discussion of what you filed against having Judge Hennett appear here, those sort of things, I've already ruled on that. There's no reason to go through that again. There's a record of that. You're welcome to to appeal whatever you would like, but that's not relevant to the decision that I have to make.
The state and the federal constitution decides whether or not material is relevant. It's not the adjudicating judge.
Well, somebody's got to decide it today, and that person's me. So I've made the decision that I had, so I'm going to ask that you move on.
Okay, and I'm doing exactly that. I'm going to continue to argue whether the court feels it's relevant or not, because I'm properly with that.
Let me just tell you, you're going to need to follow the instructions of the court, and we've made a record, and I've sustained your objection, and in just a moment, I'm going to give you a time period to finish your argument, because you're addressing things that, frankly, I've ruled are not relevant, not helpful to me to make the decision. I'm trying to ask you to tell me things that are relevant to this, so I can do my best to make a good decision. I'll do the best job that I can when the people in front of me do a good job in providing me relevant information and the case law.
Yep, and so keep in mind then, if I am not permitted to actually file any documents to the court, and I'm denied access to the court, which is unlawful and a gross due process violation, then I can't enjoy that which you just stated. And that's the reason why I'm reading through at least the index files that were filed, because they are relevant. I would not have filed them in this action if they weren't relevant. Well, and we can at least say that
if you'll stop just a moment, you've told me that they're relevant, and they're in the record, and if you want to appeal, whether or not, when I say appeal, you appeal Judge Wood's decision about that, and whether or not as a result of him making a mistake is what you contend, deprived you of a fair hearing, then that's something that can be addressed by the Court of Appeals. What I'm asking you to do is, based on the information that has been filed properly, according to Judge Wood, that you let me know what is relevant about that, what relevant arguments you have for your motion to dismiss, and what relevant arguments you have opposing your motion for summary judgment. If you do that, that will help me make a decision in the case, and I frankly would appreciate it.
I'm not going to abandon referring to the case, the filings that I've been able to actually have filed, because again, they are relevant to my motion to dismiss and in opposition to the plaintiff's frivolous motion for summary judgment. When we go to Index 28, it is my response in opposition to plaintiff's motion for summary judgment. And so we've already addressed the fact that there is no genuine dispute of material fact as to the subject matter of the case, which must be supported by clear and specific evidence as opposed to the mere preponderance of evidence. That the judgment in and of itself, if effectuated by fraud, cannot be removed. It just can't happen. The movement is not entitled to summary judgment as a matter of law. Actual defenses to a motion for summary judgment include judicial fraud, which encompasses and is generally synonymous with evidence and attorney fraud, and failure to meet the burden of proof, which must exceed the mere scintilla of evidence by the moving party. So in the elements for fraud, you have actionable fraud, which requires the showing of fraudulent misrepresentation in such form as to be a statement of fact. The fact misrepresented must be relevant and material. The representation must be untrue, and the party making the representation must know or believe it to be untrue, and to make it with a reckless disregard for its truthfulness or falsity. The representation must be made for the purpose of influencing the receiver of the fraudulent misrepresentation, and the receiver must believe and rely on the accuracy of the information provided and have the right to do so. Destruction of evidence is also an act of fraud, and I have submitted evidence of counsels destroying evidence that favored Ms. McDaniel as it relates to Plaintiff's Exhibit D, page 134 through 5 of its motion for summary judgment. And it is well settled in law that fraud is both a civil tort and a criminal wrong. In this case, because of the nature of the fraud, it is actually prosecuted criminally and not civilly. We have falsified affidavits. The affidavit to which Black refers is fraudulently prepared, suggesting that the judgment itself was a valid judgment. And even where, again, as I mentioned before, that we are not handling the overturning of the fraudulent judgment that they are seeking to renew, they can't proceed successfully on a motion to renew a fraudulently effectuated judgment. That's not what the law allows for. So it's just dead in the water, and they just have to sit still and wait for my post-judgment relief, and they can assert their claims there. But a renewal of the action is inappropriate. Also, I have my counterclaim, defendant's rebuttal affidavit. Even where I did not file a counterclaim, I have asserted the counterclaim, which was not filed in this case. And of course, you know, I've appealed. And that's as to Emily Meister's fraudulently effectuated March 27, 2025 affidavit in support of her frivolous motion for summary judgment. As it relates to her paragraph 1, I said no response is necessary. Paragraph 2, the evidence in this immediate case and the related case from which this frivolous renewal action stems, 13 CBS 008774, indefensibly demonstrates that plaintiff has expressed knowledge that the contents of her pleadings are unscrupulously falsified and conspired as such to maliciously prosecute me, effectuate yet another fraudulent gatekeeper order, which is not before the court. So that's another matter as it relates to the ridiculousness of their seeking a renewal of a gatekeeper order. We would actually have to have a hearing on whether that gatekeeper order would be relevant to continue in effect or not. That hearing is not this hearing. That can't be just incorporated impliedly into this hearing. That's not how that works. That means they need to make a motion to renew the gatekeeper order, and then we have a hearing on that. And they know that as licensed attorneys. They know that. They're just, the way that it was set up, the case designation, it was all constructive fraud. It was a good effort, but I'm on top of it. And so far we're taking care of a couple of things. To then be enforced in a corrupt, bad faith way to unconstitutionally impede and bar my appeals by right, which they have done through litigated sport, but I know, again, thankfully, Jane Jolly, I know that I can renew my motion to vacate the gatekeeper order indefinitely, and I shall. And other relief measures available under North Carolina and federal law, and gain monetary unjust enrichment at my detriment. The law does not allow you to effectuate a fraudulent judgment, then come back 10 years later and say, hey court, I'm a licensed attorney, I'm going to file this in here designated as a permanent restraining order, knowing that that's not what this is at all. And that's the reason why I incorporated that, even though you didn't allow me to finish my sentence as it relates to the restraining order. The only restraining order that was at issue back then was the restraining order that I sought against her for assault. Okay. So then number 3, as it relates to in response to Emily Meister's fraudulent affidavit, I concur that the plaintiff fraudulently previously obtained a judgment against me in 13 CVS 0008774-400. Also, in my in response to her 4th paragraph, I also concur that the judgment was fraudulently obtained. And actually it was for $4,760. And again, we're talking about the basis for that was that I had used monomaniacal in a plea. And that alone. Paragraph 5, I concur that the plaintiff fraudulently previously obtained a judgment against me in that case with the intent to subject me to a permanent, forever, into perpetuity fraudulent gatekeeper order, which is not allowed by law. I don't even have to appeal it. I don't have to assert any type of relief measure as it relates to the permanence of a gatekeeper order because there's no law that allows for it. Period. Doesn't exist. In fact, the laws actually prohibit it from being permanent, and they require that the order itself entail an option to modify. Plaintiff fails to verify any such numerous frivolous filings, this is in her paragraph 6, to be initiated concerning and or against me. It wouldn't be frivolous. I have the right, as they've already stated, I have the right to appeal. That's a constitutionally inviolate right, so that's not frivolous when I appeal the judgment. It's not frivolous when I file a Rule 60 motion. It's not frivolous when I file a Rule 59 motion. It's not frivolous when I file when I cooperate with federal prosecutors and file a criminal affidavit for judicial constructive fraud and attorney fraud and pattern fraud for the past 10 years. None of that's frivolous. They just have to get over it, and they have to then defend themselves in those cases. And that's that. This is not the format. Renewing a gatekeeper order for another 10 years, which again is just the most ridiculous notion before the court. There is absolutely no option for that, and this is not the way that they're saying that, hey, you can't argue against that judgment back in 2013. Well, equally, you can't. This is not the format to argue against your criminal prosecution that I'm proceeding upon. You need to argue it with the DAs, the federal prosecutors. It has nothing to do with it.
There's no criminal prosecution against us at all.
Thank you.
And so,
it is.
Ma'am, is there anything further you want to say with regard to the motion?
I'm not finished, Your Honor.
Well, I'm going to ask that you focus on what I'm asking you to focus on, and that is the basis for the dismissal. If there is a basis in the motion for summary judgment, your opposition to it. That's the focus of this. If there's anything further you want to say about it, I'll be happy to hear it, as long as it relates to those issues.
It does. It continues to relate to those issues. We do not concur as to what relates. And number 7.
I'm the one that decides what relates. So in that regard, you're going to need to follow my instructions as we go forward.
Following your instructions and also honoring my due process rights, which are constitutionally inviolate, and they supersede all of your judicial authority.
Ma'am, I'm not here to argue with you. I'm going to give you 15 more minutes to make your argument. And if you need additional time after that, I'll be happy to consider it. But I want to make sure we give them, otherwise we'll come back tomorrow.
No, I won't be here tomorrow.
Well, I may be. And there may be an empty chair there. And so that's why I'm trying to balance our time so that you have an opportunity to make your arguments that relate to this. I want to give them an opportunity to respond. Otherwise, we're coming back tomorrow. So yes. I'm going to ask if you can, given the amount of time that you've argued, I think a reasonable period of time would be an additional 15 minutes. Do you believe you can do your argument in that period of time?
I do not concur, but I'm going to continue to assert my rights.
Well, we may be here tomorrow.
I will not be here, and I already know that, again, these are due process violations, and it should have been continued because we actually said...
We're not arguing about what should have been done. I want to hear your arguments with regard to this particular aspect of the case, and that's the motion to dismiss and the motion for summary judgment.
Your Honor, do you regard my hearing rights?
I certainly do, if you'll proceed.
Okay, so in order to regard my hearing rights, I am doing my absolute best, and my best is pretty top notch. As it relates, I'm referring to my affidavit that is in response to their motion for summary judgment, but you keep telling me that I need to stick to the defense in that regard and arguing legal arguments in support of my motion to dismiss. But when I start, then you continue to interrupt me, and that assertively, very arguably, is the issue time-wise. Because I, too, have already communicated to the court, I don't think anybody else has a longer trip than me today. That I have the trip. Nobody else.
Ma'am, you're spending a lot of time talking about something that's not really helpful to me at this point. So if you'll focus on your legal arguments, I would appreciate that.
I'm focusing on my due process rights, and that's what the appellate court is going to want to hear. They're going to see what I've had to deal with. So I'm referring to the affidavit. We go to paragraph 7.
Ma'am, I can read your affidavit. You don't need to read it to me.
My concern is that you will not. and it is my right to be able to assert it. You just told me you're contradicting yourself, and I need to make sure that I have this clear. That's why I asked if you were regarding my rights. And again, I'm doing so, trying to make sure that I'm not presenting any type of information that, is perceived untowardly by the court when I am referring to that which I filed before the court, because my hearing rights have been restricted unlawfully. My filings have been restricted unlawfully. I am not enjoying a fair trial at all. And so I am reading through, because this is what the appellate court will want to hear as it relates to reviewing issues on appeal. It does, and I say this respectfully, what you think the appellate court wants to hear is completely moot. I am very well versed in what the appellate court deems as having properly raised issues in the trial tribunal, and that's what I'm doing.
What date was your affidavit filed?
It was filed on, and that's why I was trying to do that. It was filed on April 22nd. And this would have been, looks like index 25. You'll notice that in the index there's an order approving. Sometimes and I understand the relevance. I'm definitely not taking issue with the clerk, because they've been given way too much work. They have been burdened.
So let me ask you, so the affidavit you're talking about, Judge Wood did not allow you to file, or it is filed?
No, it is filed, but my concern is that you said that you wouldn't give me a definitive answer as to whether or not you would be reviewing the files, which is where you should start, arguably. You shouldn't start with some purported submission, off-the-cuff submission from the opposing counsel that was not delivered.
Ma'am, I'm not saying I'm not going to review the files. I'm going to review everything that's in the file that is relevant to this issue. That's what I'm going to do. In your affidavit, if you have filed it here and I'm trying to pull it up, I will review that.
Your Honor,
All right.
if it will help, in the tab 26 of our notebook is her amended counterclaim defendant's response in opposition to plaintiff's motion for summary judgment.
I object to it being the true.
And memorandum of law in support thereof. That's at the April 22, 2025, filed at 4 o'clock. At the end of that, Your Honor, if you go to after her signature page, there is a counterclaimant defendant's rebuttal affidavit as to plaintiff's March 27, 2025 affidavit in support of her frivolous motion for summary judgment. I believe that that's what she's referring to.
Your
It's
Honor,
to help the court to try to find it.
Your Honor,
That's all.
what it is, I want you to review, and that's what the court is enjoined to do. Review what I filed, not what he presented. I'm very, very apt in presenting my own filings, and it's in the court record.
Okay.
Thank you.
All right. So if it's in the record, I'll review it. You don't need to go through line by line. I'm
That's all. Excuse me. That's all I want to do.
Thank you.
Okay. All right. So then we'll move forward as it relates to my motion to dismiss, because we've addressed all the elements as it relates to motion for summary judgment. None of the elements have been met. You can't have summary judgment for renewing an action that was effectuated by fraud. Dead in the water. There are still genuine issues of material fact that are in dispute. Dead in the water. As it relates to motion to dismiss, because again, the summary judgment motion is pretty straightforward, and this needs to go to trial. It needs to be before a jury. The jury needs to take a look at this and decide whether or not a judgment effectuated by fraud for $4,000, $4,760, because I stated that Meister was monomaniacal. It needs to be before a judge. That's something before a jury in that. As it relates to my motion to dismiss, we go back to Rule 12B, and again, And I believe the court is saying that it's going to, I believe one of the trial court administrators said that they were going to forward it to you, so I no longer need to forward it. I want to make sure that's clear.
Yes, ma'am. It looks like they have forwarded the information.
Okay, and you'll notice that Black he is CC'd in all of those emails. For the sake of the court, like I can forward the emails, but I don't want it to be voluminous, so what I'll do is I'll just print it so that you see that they've been included in all the feeds. I very seldom, even when I submit pleadings for the purportedly narrative review process, I typically consistently include them, even though they don't have a dog in the fight.
It looks like
relates to that.
I've received 4 emails that were forwarded to me from Ms. Robbins, so it appears that whatever was sent has been sent to me, so I have it.
Perfect. All right, so in that regard then, what we're referring to is the lie. And, excuse me, you said don't use the term lie, even though that is factual, so it is factually false. Is that appropriate?
You can continue.
Okay, so it is factually false that that there is a gatekeeper order that was entered for 10 years. It is factually false that renewal of a gatekeeper order purporting that they want it for another 10 years, that also is factually false. So we've talked about the legalities of it. So there's no legal cause of action, but I want to talk because you've asked me several times to make sure that I'm presenting the facts to you. So there's no legal substantiation, no claim under North Carolina state law that allows for renewal of a gatekeeper order for a 10-year stint. There's no claim for relief, nor do gatekeeper laws even allow for that gatekeeper order that qualifies that he entered in 2014 to somehow have been for the period of 10 years. And opposing counsel's analysis in that regard is just it goes against everything that the North Carolina General Assembly has stated as it relates to engaging litigative sports. And they vehemently reject it. Okay? So when we talk about the facts, and again, we're not talking about necessarily the overturning of the judgment here, but we're talking about the facts that surround the renewal of the judgment. And this is what I was referring to earlier, Your Honor, when I said that I believe that they would argue this, that my evidence is somehow just ancillary and therefore immaterial. Ancillary evidence is still probative, or can still be probative. And it is probative in showing the pattern and practice of the constructive fraud and showing that they have already committed the act of fraud of effectuating the first judgment that they're seeking to renew. Okay? So there's no factual basis. You see what I mean, Your Honor? I hope that's making sense. I hope that's landing. There's no fact in that order that there was an order entering a gatekeeper order for 10 years. And now it should be allowed to renew it like a regular judgment would be. This is not what that is. So there's no facts in that case that support that argument at all. Okay? Then when we talk about the last thing, and it looks like I can resolve my arguments, at least minimally, even though I'm still not confident that the entirety of my MOL will be reviewed. The last thing, and it is very telling, let me go back to it and make sure I'm... Just give me 1 second. I've got a smudge on my glasses, and when you get a smudge on your glasses, it's like I can't get it off. I need my microfiber cloth, and it's just not helping me right now. So, okay, so that's why it's taking me a little bit longer here. Okay, so then within that document, my response in opposition to the motions, the plaintiff's motion for summary judgment. I also filed my verification for my April 17th response in opposition to plaintiff's motion for summary judgment, and my supplementary pleadings. And there are a few exhibits that I just want to call your attention to, and then I will rest my argument, even though only in that I'm not being permitted to assert the rest of my MOL in open court. Okay, here we go. All right, so then we just go right back to the North Carolina Superior Court Judges Bench Book, which is number 72. I don't know how, that would be a quick reference, but I'm also very sure that you're familiar with that bench book as it relates to gatekeeper orders. The plaintiffs have also effectuated this gatekeeper order. Remember, it is substantive to this motion for summary judgment, because that's what he's seeking to have renewed, which of course there is no claim for relief in that regard. But they're seeking to, we know, impliedly, because they have actually registered this gatekeeper order in evidently 72 counties, which is completely against the law, because the gatekeeper order or gatekeeper order laws states that it must be narrowly tailored. The order needs to be narrowly tailored to the circumstances showing abuse. If that were the case, again, we're not going to litigate that case. I got that under control. I'm talking about what they want to have renewed. They want to renew somehow this gatekeeper order in 72 counties where I've never been. What? The order needs to be narrowly tailored to the circumstances showing abuse. That is, if all abusive litigation is directed at one particular party, the order should only limit filings related to that party. Or if the frivolous filings are all in one county, the order should be limited to that county. I have not ever, as the only exception is proceeding upon the Wake County action, and that's only because it involves the state as well as a defendant. Otherwise, I would have filed that action in Guilford County. But considering that that would be the jurisdictional premise for that, then that's the only reason for me moving forward with that case and naming her as a defendant in that action. But that wouldn't have been the basis, because remember, they just told you that they just found out about it. So that's not the basis for their motion for summary judgment. Their basis of this motion for summary judgment is on that which they have already done. Everything they've done, filing it and registering this gatekeeper order in 72 counties, and that's where the relevance of those exhibits P through U, They show that the courts that have taken notice that what Huffman said, that I filed 162 cases in 72 counties, stems from what they did. And then it was copycatted in 3 different counties. And we know that is it's factually false. Not only factually false, because it's been done, and we know it's being done by licensed attorneys who know how to check the case records, who know how to interpret and analyze statewide case records, then they're doing it intentionally because it's demonstrably so. So that defeats everything that they are intending to do fraudulently through their motion for summary judgment. It cannot be renewed and then renewed in counties where I've not even had a hearing as it relates to a gatekeeper order, and thereby I'm being subjected to a gatekeeper order, and this continued copycatted factual falsity in these counties is just, it's reprehensible. It's reprehensible. And again, I'll handle that in a separate action. And lastly, I just bring your attention to, again, I stated already, but I just want to read it verbatim to the court, opportunity for modification. The order should include an opportunity for modification. For example, the order might allow the affected party to seek a change after 6 months or 1 year. That's actually what Judge Hennett had ordered previously, that it would end in 6 months. And it was only entered to keep the peace between myself and Meister based on the volatile circumstances that led up to that case. Or it says, or the order might provide for automatic review by the court after a set time, but this court has not ever regarded my constitutional rights, albeit like maybe minimally so here and there, and there has been no point. I've literally filed my motion to, my renewed motion to vacate the gatekeeper order, I would say at least 10 times. And the filing, just the filing of it, has been denied. And that goes completely against, reprehensibly against gatekeeper laws which are prevailing.
Thank you.
Mm-hmm.
If I could just ask the plaintiff, so 1-47 says, upon a judgment or decree of any court of the United States. So what I have, it looks like is an order, it's not designated as a judgment. You believe the order with sanction is renewed in the same process as a judgment? Was this entered on the books as a judgment, or is it?
The way that I understand it, Your Honor, is that orders are treated as judgments of the court. We have not been able to find, Your Honor, a case that deals with this issue in North Carolina. And I admitted that at the very beginning. But one of the things that I would say, judgments and orders don't normally have it doesn't say judgment is good for 10 years. It doesn't say an order is good for 10 years. The court enters the order and enters the judgment, and by statute, they appear to be limited to a 10-year time frame in North Carolina. That is the reason that out of the abundance of caution, we filed the complaint to have it renewed. Again, Your Honor, the case that I handed up indicates that it has to be an independent action. We can't have done it in the 2013 case. It has to be an independent action. And so, for the purposes of summary judgment, there's not an issue of material fact in that there is the gatekeeper order and the judgment for the amount of money. We filed timely. And that appears really to be the two elements of it that we have in order to renew it. It has not been satisfied. And, Your Honor, I want to point out a couple of things. She indicates that
if I can ask you related to that. So, the judgment is collectible on the books. Sometimes money is intercepted to pay for judgments. Orders are generally enforced by contempt, by somebody bringing in action and trying to find if someone's in contempt for willfully failing to comply with an order. Right. And so, have you all made an effort to do that at any point? have a contempt hearing for failure to.
Your Honor, that would not.
I'm going to hear from you, but I've listened to what you've had to say. I've got some questions for him, just as I have questions for you.
Your Honor, we have not filed a motion because I don't know what the motion would be. It wouldn't be for contempt, per se, because of the fact that there would have to be something that would happen. The way that we
you say that, but I mean, it's an order sanctioned for this amount. It's an order to pay funds. I assume that will come with a reasonable period of time to pay. You know, if it's an alimony order, a child support order, if there's any type of order like that, typically folks would, if they have some basis for thinking somebody's willfully failed to comply, they would file a motion or seek a judge to enter an order on a show cause hearing for contempt for failing to comply. You all have not proceeded that way, is that correct?
We have not proceeded that way. We chose to do it this way because of the fact we believed that it was the one that made the most sense. But, Your Honor, here's the deal. It seems to me this. Either the order is permanent. We don't have to do anything. Because it does not expire on its terms. It's an order that says she cannot do these things and she is limited, and if she wants to file a lawsuit, and I believe it's actually narrowly drawn as far as it relates to Guilford County and as far as it relates to the other counties of the state. It simply says she can't sue me, my partner, or my law firm in any other county in the state. It doesn't restrict her from suing anybody else in those other counties. So from that aspect of it, it's narrowly drawn. But it seems to me, Your Honor, that either it's a permanent order, and I don't have a problem with you saying, listen, I think that this thing could be it should be dismissed because of the fact that the order is permanent. They didn't have to do this. The order is a permanent order. It doesn't say that it's a permanent order, but it does not expire on its terms. And so we took the position that the safest thing to do would be to file this action and try to renew it out of the abundance of caution, and that we didn't want it to expire. And there's reasons for that. In 2023, she filed a motion to have it set aside. And so we had to deal with that, which was appealed, which we had to deal with that. And so there's reasons that it needs to stay there, and that's the reason that we took the approach that we did out of the abundance of caution. But as of right now, I think that's the safest thing to do. And that's the reason that we have taken that approach. And so we would ask that you find that it is as a judgment, because the order was a judgment of the court. There's order, judge, and decree. You know, it's a judgment of the court that she is ordered to do these things. We interpret that to mean 10 years. We haven't found any case that says one way or the other on that issue. But to make it clear that it's for at least 10 more years, we don't have that issue. I want to really address one other little thing, because and it's probably unnecessary because it deals more with whether Ms. McDaniel is being factually accurate with the court when she makes some arguments. But she keeps arguing about the fact that she had no knowledge of the $4,600 judgment. If you look at that judgment itself, she appeared and put on evidence and argued that case. She was there. She was there when the gatekeeper order was heard. And she had the chance to do it. She had the chance to appeal those orders and judgments. So, Your Honor, it appears to us that it's either a permanent order, and this is unnecessary, but I'd like a court's ruling that that's what it is in dismissing this action, because of the fact that if it's a permanent order, that's what we're asking for. We know that we can't, under the law, ask for a permanent order, a permanent judgment, because that doesn't exist. we're willing to accept a 10-year more. We're willing to recognize that we have one more 10-year period, that we should not have to have something like this that has taken an inordinate amount of time. If you look at all of the filings since we filed this in November of 2024 to pass, the number of appeals that we've had to address and try to figure out what they are, there's just a tremendous reason that Ms. Meister's individually and our law firm should have the protection that is contemplated by the gatekeeper order. And so we're asking that you do that, and happy to answer any other question you may have. But I don't have a lot of other answers.
So I'm trying to think through, I mean, what this is, it appears to me, if I look at it more carefully, it seems to me this is a sanction of the court. It is a sanction of the court directing that as a response to whatever happened way back when, that this, assume this is attorney's fees, is what the sanction was for, and that in response to the conduct that lawsuits not be filed against you all. Seems to me that what I'm trying to think through is I don't think it's a sanction of the court. I don't think the court's inherent authority to direct that certain things happen. I don't know that they expire with that statute. If it's seen as a judgment, then I understand the argument about that. But either nobody's moved or people have moved. The court has not set aside that order. It doesn't seem to me to have an end date at first blush, and that I'm not certain that's a judgment. Or maybe, I mean, I read the statute. It says judgment or decree of any court. So is this a decree of the court in line with a judgment in which a money amount has to be renewed or would expire after 10 years, or it's different in that this is not something that's indexed. A financial judgment, it may be a permanent record of the court as to a sanction. So that's sort of trying to think through, what exactly is this, and how we categorize it. Then, does it expire? If it does expire, can it be renewed, or is this a permanent order until it's set aside? That's sort of what I'm trying to think through.
As I said, Your Honor, that's the reason we did what we did, is because of the statute that appears to potentially cover it. If it's not covered, then it's permanent, then it's still here, and it's not. We can plead that, and if she violates it, then we could move forward with contempt. We just, because of the fact we couldn't find a case, didn't know, and in light of the statute and reading it, because it talks about judgment and or other 24, that under the caution, and we were willing to do that. As far as it relates to the monetary, the $4,760, the actual judgment is that sanctioned in the amount of $4,760 for her violation and for her conduct, and judgment is hereby entered. So for the $4,760, it's clear that for that to be renewed, we would have to have done what we did.
Well, it says that, but it's captioned as ordered. So when the judge looks at that, has that been indexed as a judgment of $4,000 against her previously? Do you all know that?
I'll be honest with you, I do not know off the top of my head.
Okay.
But I mean, that's another basis for us doing what we did. I would hope that the court could understand our reason for wanting to do everything we thought necessary to be able to protect Ms. Meister.
Thank you. You want to respond to those legal questions I asked, Mary?
Without question, because none of them are valid. So number one, there is, and it sounds like you are litigating from the bench, to be honest. As it relates to the
Well, let
permanent...
me just say, I'm sorry it sounds that way to you, but the way I do this is I ask questions of people for answers that I'm not certain of. And so I ask them questions to give them an opportunity to explain it, and I'm asking you the same questions to give you an opportunity to explain it. When I say it seems to me this is what it appears at first blush, I've made no final judgment about it. I don't know the answer to it. I don't know the answer to it. I'm going to have to look it up. But before I go and look it up, I want to give you all an opportunity to tell me what your position is on it. So that's why I'm asking. I'm not trying to be on one side or the other. I'm trying to figure out the right way of doing it.
It's impliedly on one side or the other because I just gave you the case law that is binding. Anytime that I presented any case law, or statutory law, because it's not just case law, the gatekeeper laws prohibit a gatekeeper order in the manner that they intended.
Let me just say, I've heard everything that you've said. I've heard everything that you've said.
But I have additional, as it relates to the questions that you asked.
Yes, ma'am.
So number one, he is making another factually false statement. The gatekeeper order does not bar me because it can't. It cannot bar me from initiating actions against them. It limits and restricts me from filing actions against them that have not been approved for filing. And all of the filings that I have made have been approved for filing, obviously, because they've been filed in whatever county. So there is absolutely, so that is a factual false statement. He knows that. And it seems like this court is very, very so much favoring them because they're not paying attention to the very finite language of the gatekeeper order.
I'm just going to ask that you not do any more commentary about what I'm doing and how I'm doing it. I'm sitting in the middle, listening to your arguments. I'm going to make a judgment about it. If I'm right, I'm right. If I'm wrong, if you appeal it, the appellate courts will say. So if you want to talk about the legal arguments, I'm happy to hear that. I'm not interested anymore in hearing your view of how you perceive how I'm going to do this, because I haven't done anything yet, and I've told you that I'm sitting in the middle, trying to do this the right way, listening to your arguments. That's all that I can do.
I'm referencing, and again, all that I can do is assert my due process rights. And when you ask these questions, I then have to respond to them to assert my due process rights and respond to factually false statements that they're making. In his order, it says, defendant, let me go to it, make sure. Defendant shall be limited from initiating any complaint in the Superior Court of the 18th Judicial District of North Carolina unless it is first submitted to and approved by a resident Superior Court judge in the 18th Judicial District. This also, when you go down to this paragraph 7, defendant shall be limited from initiating any action against plaintiff Keith Black, Jennifer Reuter, or Wasabi Black Slaughter, including any of its employees, whether civil or criminal, in any county in North Carolina, unless first submitted and approved in accordance with paragraphs 2 through 6 of this order. So and that follows, in that particular regard, it does follow gatekeeper laws, because if she were to do something to me separate from even this action, or in addition to this action, that is unlawful, and there is a valid claim for relief for which that is allowed for under North Carolina law, none of you would be able to lawfully allow for me, to deny me from proceeding on that. And that's exactly what I have done. And again, my complaint against Emily Meister and the state for injunction has been approved for filing. Okay. So that, number one, is dead in the water. There's no such thing. Also, as it relates to a motion for consent as to the gatekeeper order, it wouldn't be relevant nor proper in any way, shape, or fashion because I have been approved for my filings. Everything I filed has been approved. That which I have filed in these cases, they have all been approved and demonstrably so.
Nobody's saying no.
You asked the question, Your Honor, of whether or not they had moved for consent. It wouldn't have been proper on any day of the week because there is absolutely no substantiation.
Let me ask, if somebody has money owed, an order that directs that they pay money and they don't pay that money, in other cases, folks regularly file motions for contempt for failure to pay money. That was my question. Had anyone ever done that?
And actually, I'm glad that you brought that up. I'll close in that regard. As it relates to the motion for sanctions, he's also made another factually false statement. You see, as I mentioned before, yes, I was absolutely present for the initial gatekeeper order that Carl Fox entered in 2014 after Judge Kennett entered her order earlier directing that they not do all the things that they did. It's relevant. It's relevant. We're talking about the 2017.
I'm going to hear what his objection is. I'll give you a chance to respond.
Yes, I'm objecting to her talking about an order that is before the two orders that are the final orders in the case, Your Honor. That I made that objection before you sustained that objection before, and so I would ask that you do that. Your Honor, all I'm asking you to do is give us the relief that is in the existing orders. That's what we want.
There is no relief available.
Nothing more.
Yes. There is no relief available to them in the existing order. This is their way of trying to skate around the court to continue to conceal their fraud, period. That's all this is in the story. This court should have reprimanded the fact that they have made factually false statements about the contents of even, if I had done it, you would have. You would have had that bailiff arrest me, guaranteed, because you already threatened me with it earlier. Guaranteed you would have. Guaranteed. As it relates to me bringing that up.
Let me just say, I'm sorry you feel that way about it. I think I've tried to be as patient with everyone as I possibly can. That's where we are. If there's anything you'd like to say in concluding, I'd be happy to hear it.
The reason why I brought that up is because it's relevant for the legal question of contempt and the fact that the substance of your question is, hey, did you follow the previous order? You see that the first order that Carl Fox entered, I was present for. I did argue vehemently against. I've spoken out about that ad infinitum. The second order, so the first order that was entered, if you recall at the beginning of this hearing, and I know you've heard a lot, there was a judgment for $1. Do you recall me saying that? That judgment was that first judgment. They had factually falsified that I was present for the second judgment, which was entered, I believe he said, in 2017. I didn't learn about these things until later. I didn't know anything about a $4,760 judgment. I learned about these things, and I stated this. I referred to the legacy scan. I didn't even have access. There were times where, you should have recalled me stating, there were times where I had come to visit because I had moved out of the state. I had lived a very gainfully colorful life with my professional career in academia. And I had been in Arizona and elsewhere, California. I did not know anything about that particular judgment, and the times that anyone would bring it up, and I'm talking about the case with Meister from which this stems, anytime they would bring that up, or the 172 cases in 652 counties, I would then make an effort and try to look into it further by coming to the courthouse. But I've told you before that there would be times where the clerk of court would not even provide me with the actual access to the case. So I didn't get the fullness of the actual case until actually there was the electronic or e-filing integration and was able to pull up the legacy scan that they just did, Your Honor. Literally just did. So now I have all the documents from that original case, and and there's no way that they can state with a straight face, but of course they will. But the record is finite. It shows that judgment was effectuated in fraud. I was not there. There was a service issue. I was not there. Yes. So in that regard, then there can't be a contempt on a judgment that was entered against me if I had no knowledge of it. Also, there can't be a contempt of that judgment if I have actually moved for post-judgment relief. They just need to go through the process, and if they want to defend themselves against my post-judgment relief, but they're not ever getting a dime from me because they're not entitled to a dime, not a penny, not a half a penny, nothing.
Ma'am, I appreciate that. Let me just say where we were is that I am going to take it under advisement and give you all an opportunity. The plaintiff has 24 hours to file any response they wish to do. If they don't file a response, I'll consider the case submitted. If you do file a response, ma'am, you will have 24 hours from that point, from Wednesday at 5 to I say file a response. Send an email to Ms. Robbins. So,
Your Honor,
give me a moment. So, to be clear, 5 p.m. tomorrow, if there's some response you want to make to the documents that I understand that you wish to review, please submit that to Ms. Robbins. If he does that, then you have till 5 o'clock on Wednesday to respond to that document, and I will take that under advisement and consider. Yes,
the reason why I wanted to speak, I have court the rest of this week. I have court tomorrow in Mecklenburg County. I cannot do it. I would, because I am, they use it to insult me, but I am fast, and I can file a plea very fast, but I can't do that. I'm driving down the road. I got to go to court in the morning.
How long would it take you, ma'am?
I'm sorry?
How long would it take you if they file something for you to respond?
What do you mean? I don't have a problem with the 24 hours. I have a problem with the 24 hours tomorrow because I'll be in court.
So,
and then I'll be in
if you listen
the court.
to me, maybe I misexplained it. They have 24 hours. They have 24 hours to file a response to the documents that you submitted to me.
5 o'clock on Tuesday.
And if they don't do that, then I'll consider the case submitted, take it under advisement, I'll review the materials, and I'll issue the decision. If he does indeed file something by 5 o'clock tomorrow, then you have 24 hours to respond. If that's not enough time, tell me how much time you need.
No, that's why I was saying I'm in court the rest of the week. I'm in open session.
Right. So how long
I
do you
need next week.
You need next week. How long next week?
I do. Hold on one second. Well, see, I don't even have my thing. So I have
How
a
about
hearing on
Monday?
the...
That'll give you the weekend. He's got to review all of this by tomorrow at 5. And so if you had till next weekend, the end of the Monday, would that give you enough
next
time?
weekend, because I have cases. You have to understand, Your Honor, and I would imagine that you would be respectful of that I'm well respected in other jurisdictions. I cannot, I have hearings in Mecklenburg County the end of this week, tomorrow, and then next week. I have filings that are due on the 22nd, the 28th, and so, but as long as it's due next weekend, I should be fine.
Well, so Monday the 26th at 5 p.m., that would give you the weekend to respond.
No, not this weekend. Not this weekend, Your Honor. I have 2 informal briefs. The smiles are so disrespectful to me right now.
I'm not smiling at you at all. I don't know what you're talking about. Yeah. Yes, sir.
I was just going to say, you're giving us 24 hours.
Yes.
Of something that evidently we received today for the first time. That's fine with me, Judge. We will do it within 24 hours. But considering it would just be her having to respond to whatever it is we do, if anything, I would certainly think, Your Honor, that she's got a busy day. I'm supposed to be a mediator all day tomorrow in the case. We'll make 5 o'clock. That's fine. We'll get it done. But it needs to be, she needs to be.
No, I do not. That's not.
Ma'am, I don't want you to interrupt. I'm going to hear from him, and I'll hear from you.
Treat her the same as you treat us. We get 24 hours. She ought to have 24 hours to respond to whatever we do, if anything. I don't know if it's what I truly think it is. We're not going to say anything.
All right. Yes, ma'am.
He doesn't have a dog in this fight. The fact that you're even entertaining it, I find very interesting. When you won't allow me to do to actually honor my full hearing rights. To keep hearing from him in this frivolity is ridiculous.
You want to come back tomorrow?
I'm not coming back tomorrow.
Okay,
I would love to. I am actually.
Let me just tell you, it is 5:11. If we measured out how much time each of you took, you had considerably more time, and you're telling me you don't want to come back. So it's hard for me to understand why I haven't allowed you to argue your case.
Because of the complexities, whether or not it takes me 2 hours or 3 hours, I've not had this opportunity at all. I understand that you believe from your seat that you have done, you have served my due process rights in regard to them. Imagine that which I've actually suffered prior to this. So this little bit of time that I've been allowed, far exceeds the 10 years of fraud that I've been subjected to. So yes, I do need more time, and that's what the law provides. I'm not asking for, and let's be very transparent, I'm a witness in a criminal trial on tomorrow. So that supersedes this court. So we're not talking about just mediation or something to that effect. I am not just touting this. I also have to deal with Judge, and if you feel the need, please do reach out to him, because he was concerned that I couldn't be available at the date that he wanted because I was before the Wake County Court at a certain date. Normally, we regard the availability of all parties involved equally. He doesn't have a dog in this fight as it relates to 24 hours. I need to be at this case. It involves the well-being of me and my son, and I'm not going to get into the details, but I've already stated that in the criminal matter, you may check with Judge Roy Wiggins. I am before that court. I have a brief due on the 22nd, the 28th. I homeschool my child. He has a science test on Thursday. I have already fit into my life everything that I need to do. I'm submitting myself to the court, paying for transportation when this could have been held remotely. I have done it. So I cannot even stand for the court even thinking remotely that somehow that anything that he's saying that I wouldn't be somehow held to the same expectations. It's reprehensibly
Thank you.
It is too much, and this needs to end. Everything that they've done, it needs to end, and they know it.
Thank you. Ma'am, in this matter, I'm taking it under advisement without objection to give you all an opportunity to respond. I'm going to ask, sir, that you respond in one day by 5 p.m. Tomorrow. Now, I'm going to give you 6 days, May 26th at 5 p.m.
Thank you.
That will be submitted to any response that you have to Ms. Robbins. I would say that if the plaintiff does not file anything in response, then I will take it under advisement and do my best to get it decided by the end of the week. Thank you all very much. Have a nice day.
Thank you, Your Honor.
Please,